So, my lord, it is already ordered to be come in normal course of hearing, the second appeal. So, may it be listed after 2 weeks, my lord,
After vacation?
after eviction.
Your lordship, in this matter, kindly a date may be fixed.
No. Actually, registry is also requesting me not to fix dates. If the matter is very old, then I can fix a date. But if the matter is not very old, then registry is requested me not to fix dates.
May I pray? The one.
Item number?
41.
Yeah,
May I pray?
after vacation.
And clerical mistake may be required to correct, my lord. Only for that reason I have filed an IO.
Hmm.
It may be taken on today itself, at the first of my lord.
Today, I don't think they'll be able to fix. Tomorrow.
No, tomorrow I will not be available, my lord.
Your junior, anybody junior to you, it's only a correction matter, you can submit. Only a correction matter tomorrow.
It is today.
Today, I don't think, then day after tomorrow. Day after tomorrow is a holiday.
My lord.
Today, it won't come.
Today. I think that already that is the case is in the they may be sent immediately.
Okay, let's try.
I shall try, my lord. No much.
May I please look at RSA number 2225 for 2016. May list and confidence of the your court. I am going to withdraw the case.
Sorry?
For withdrawal.
Withdrawal.
Withdraw.
7.
7.
May I please your lordship?
No, item number no. Withdrawal.
May I please your lordship?
Hmm.
I beg to mention item number 33, lordship. With the consent of the other said lordship, the matter may be kindly listed after location.
3030.
33. 33.
Okay. Current counsel, Mr.
P.K. Basu.
P.K. Basu.
P.K.
On behalf of
A. Biswas.
current counsel.
Asel.
Oh, assessor. Okay. Learned counsel, Mr. P.K. Basu, with the consent of the other side, has prayed for adjournment. List the matter of.
Asel. Obliged.
May I please, your lordship?
Hmm.
Lordship, back to mention for listing for withdrawal, lordship.
Hmm.
On 17th.
May I please, your lordship?
May I please, your lord? But I am praying for listing, my lord, appeal, my lord, today, my lord. Custody appeal, my lord, my 8 years son, my lord. Although, my lord, proceeding has been stayed by the Sound Court. Ex parte order has been passed, my lord.
Not today.
Tomorrow, my lord.
Tomorrow,
Tomorrow, my lord.
fine.
Tomorrow.
Tomorrow we have hearing fixed for 33 cases, which is not at all possible. 33 cases fixed for hearing already on request by everybody. 33, can it be possible? I'll have to, many matters will be left over tomorrow. If you want, I can fix it tomorrow.
Tomorrow, my lord. We'll
At
try,
the
my
end
lord.
of the call, please.
Flush.
Okay.
Obliged.
May I please, your lordship? Prayer for listing, lordship, for orders, lordship.
End of the matter as end of the list. Silo check reply.
May I please, your lordship?
Form dice na?
May I please, your lordship? Prayer for listing, lordship, for orders, lordship, 2018 matter, lordship. So, lordship, Monday, lordship,
Monday by on 18th.
2 matters, lordship.
May be result also, lordship. I have already filed one IA matter in respect of the lordship.
Analogous matters. Analogous matters or two different matters? Just a moment.
Difference.
The beleg date video.
Lordship, I have filed one IA lordship in 23 May of 2025 in MSc appeal lordship, but till that case is not listed lordship. So matter may be lordship 6 on 17 and lordship
Appeal.
appeal in IA filed in
At stage.
not appeal lordship. I have filed one IA for releasing the amount which has already been deposited before the court, but that matter has not been listed in the IA matter.
What date of the action check please? 19.
19. Also, another key matter has been mentioned for they are not listed lordship on so long term. The matter is 2018 matter lordship for orders matter lordship. Till the
No, I
lordship
don't think we'll be able, will come after puja vacation.
after
Those 3 matters will come after puja vacation.
vacation give and submit today. The
Yes, you
mentioned
can
ma'am,
submit or you can submit later. It
letter.
will be better if you submit on the last day of the before vacation.
Yes, yes,
On the last day or previous to that date?
yes, yes.
Lordship,
This-
beg to mention
and-
item number,
I matter is 18, 19. Okay.
Lordship, beg to mention item 15 and 16, Lordship. In item number 15, Lordship, he is for the appellant.
For the appellant.
And in respect of 16, I am the appellant,
Cross appeal.
cross appeal, Lordship. Both the appeals are admitted, Lordship. So may I pray that both the matter may be listed for hearing after vacation, Lordship. Item number 15, both are, Lordship, out of same judgment. Rara appeal, Lordship. 15 and 16. In item number 16, Lordship, he is appearing for the respondent.
Okay. As both the parties are, both the parties are represented. We have received the LCR,
Lordship.
Huh?
Lordship.
trial court record. We have received the trial court record. This matter may be listed for hearing after vacation. This
After
matter is to be listed for hearing after vacation.
Lordship.
Obliged.
Only in respect of item number 16, Lordship, name of the counsel for respondent may be reflected.
Item number 16, the name of the counsel, Mr. S.
CK Bhattacharya.
Dika Bhattacharya, is to be reflected in the cause list.
Lordship.
May
All
please your lordship. Lordship, I'm praying for listing of the CRPIO in the motion column, lordship.
Hmm.
In the quote below, case is fixed on 19-9, lordship. So there is urgency.
Motion.
7, oblique.
May please your lordship, I beg to mention for IA, for releasing of the amount, my lord, insurance company already deposit comments. 18, my lord, then 19 or 16, my lord. 19.
May appeal refused. Not to consider of opposite side, I beg to mention item number 12. Matter may be after vacation. 12.
Learned counsel, Mr.
Is Islam. Appeal.
H. Islam has prayed for adjournment, list the matter after. You have taken consent of the other
Yes,
side.
yes.
With the consent of the other side has prayed for adjournment, list the matter after vacation.
May I please your lordship? Lordship, I am praying for listing of an RSA which was last listed on 28th February of 2025 for orders for next week.
Next week orders of fairness auction. Finally, 19 September.
Oblige you.
Lordship, I would like to mention listing the matter, which was last posting was 29/5/2024. Kindly listed the
In which column?
RSA matter
For hearing or for order?
for admission,
Sorry,
admission.
for admission. After vacation. You come on the last week, after vacation. For admission, that cannot accommodate, not possible.
May please your lordship, I beg to mention one RSA for listing. The matter may be taken up on 14th of October, my lord.
14th of October.
Yes, my lord. If time permits. Earlier.
May please your lordship. Lordship, 3 MFAs are to be listed. These are listed 2017 only for hearing.
At which stage?
Hearing.
After vacation, after vacation.
May I please your lordship? Matter is the orders matter, MSc appeal matter, maybe it is listed next week, my lord. Next week on any day, my lord. Next week. Monday, my lord. Monday. Oblige, my lord.
May please your lordship. Lordship, I beg to mention item number 21. We have taken consent from the other side.
We have for the respondents.
21.
Learned counsel, Miss?
B wrong hang. B wrong hang.
Lordship, the
letter may be fixed on Monday.
Oh, this is pending at which column? Orders. On behalf of
AK Protestant.
Learned counsel, Mr. AK Pukeshwar, with the consent of the other side has paid for adjournment, list the matter. 19 September.
Measures.
Your lordship, I'd beg to mention an MSc appeal for listing tomorrow, your lordship. The matter being urgent is because we have entered into a agreement with the insurance company. A certain new fact has to be incorporated through a medium of additional affidavit. If the case is disturbed tomorrow, I'll take the leave of this court to file an additional affidavit, your lordship.
May I
Deeply
please
obliged, your lordship.
Lordship, I beg to mention listing of an IA for orders next week. Obliged.
Item number 1.
Wait, please. But in this case, the order of the learned chairperson of DRAT Kolkata, my lord, that is under challenge. So the very simple case is that, my lord, an appeal was filed against the order of the DRT Guwahati. I'm trying to make it as simple as possible. An appeal was filed against an order of the DRT Guwahati. Now, under section 18 of the SARFAESI Act, my lords, when we file. Yes.
Okay.
The lordship will kindly have section 18.
Securities and credibility has a demo. No, no. এখন সৰু কিতাপখন সৰু নামটো দিও Yes, okay.
Yes. The lordship will kindly have section 18, my lords. Now, section 18, my lords, any person aggrieved by any order made by the Debts Recovery Tribunal may prefer an appeal under along with such fee as may be prescribed to an appellate tribunal within 30 days from the date of receipt of the order of Debts Recovery Tribunal. Provided that this is, we are not concerned, my lords. Second proviso, provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of debt due from him as claimed by the secured creditors or determined by the DRT, whichever is less. Third proviso, provided also that the appellate tribunal may, for the reasons to be recorded in writing, reduce the amount to not less than 25% of debt referred to in the second proviso. Now, in very simple language, it means that normally 50% of the amount due, and however, for reasons to be recorded in writing, the DRAT may entertain the appeal, but mandatory minimum 25% of the amount I have to deposit. Now, my lord, if your lordship comes, my lords, first of all, my lords, to page 88, my petition. But this is, my lords, an IA was filed for exemption of the waiver deposit for the purpose of entertaining the appeal filed under section 18 of the SARFAESI Act. So, my lord, I can file an application for waiver. The learned chairperson is to consider it on its merits. And of course, while considering, my lord, the prima facie case, it is very similar to, let us say, an injunction, my lord. That way, prima facie case has to be seen, whether I have any case or not, or I have just gone there to waste the time of the electricity. That is the sum of the matter. Now, my lords, your lordship will see in the application, I have raised, my lord, large number of points on merits. Lord, it's a very elaborate application. I do not want to take much of your lordship's time, but several grounds are, my lords, made. As many as, my lord, 11, 12 grounds are there. And the relief, your lordship, comes to page 102. The relief is claimed. In view of the facts mentioned in the paragraph above, appellant prays that your honor may be pleased to admit this instant application and further pass an order directing exemption of waiver deposit under section 21 of RDD BFI Act or any other law in force for the purpose of entertaining of the appeal on merit of the facts of the case. So this is the, actually, my lord, it should have been said that exemption, full exemption cannot be granted. That is the law. There is no. So I have to deposit minimum 25%, maximum is 50%. Now, Lord, if your lordship comes to the impugned order, which is at page 106, ma'am.
106.
Yes, ma'am. When the waiver application was decided, ma'am. If I may read, ma'am. IA number so and so application for waiver for making pre-deposit as required under section 18 of the SARFAESI Act. Instant appeal has been preferred against a judgment and order dated 26/7/2024 passed by the learned DRT Guwahati dismissing the SA number so and so. Appellant herein is a borrower of the respondent number 1. As per the notice under section 13(2) of the Act, an amount of rupees 1,98 lakh so and so was the debt due as on 27 July 2021. Thereafter, certain deposits were made by the appellants. Secured assets were auctioned on 18/5/2024 wide notice dated so and so for an amount of rupees 1.32 crore. Learned counsel for the respondent, that is the bank, submits that as on the date of the filing of the appeal, an amount of rupees 1,53 lakh so and so was the debt due. Learned counsel for the respondent would submit that the appellant is liable to make a pre-deposit of the sale consideration, i.e. rupees 1.32 crore in view of the law laid down by in Messrs. Siddha Nilkan so and so. Lord, it is not understood as to what is meant by this line, make a pre-deposit of the sale consideration, because property is sold
and I cannot deposit something which is sold by them. Now, at the end of, I'll come to the judgment part, but she will come to the end part. In view of the law laid down by the Honorable Apex Court, appellant is liable to make a payment of 50% of the debt due. He cannot take advantage of the sale consideration. Accordingly, IA number so-and-so stands disposed of with the direction to the appellant to make a pre-deposit of 50% of rupees 1,53 lakh. So, essentially it was dismissed, though it is written disposed of. Now, if your lordship comes to the quoted part of the judgment which is relied upon, which I bow down respectfully, that is the law. But what is the law? Let us read that para 13 of Siddha Nilkant. The lordship will kindly come. It is there at page 107. As per section 2 so-and-so of the Sarfesa Act, debt shall have the same meaning assigned to it in clause G of section 2 of the Act of 93. As per section 2G of the Act, debt means any liability inclusive of interest which is claimed as due from any person by a bank or a financial institution during the course of any business activity undertaken by the bank or the financial institution in cash or otherwise, whether secured or unsecured or assigned, or whether payable under a decree or order of any civil court or any arbitration award or otherwise, or under a mortgage, and subsisting on and legally recoverable on the date of the application. That the debt means any liability inclusive of interest. As per section 18 of the Sarfesa Act, any person aggrieved by any order made by the DRT under section 17 may prefer an appeal within 30 days to an appellate tribunal from the date of receipt of the order of DRT. Second proviso to section 18 provides that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of debt due from him, as claimed by the secured creditors or determined by the DRT, whichever is less, and only then an appeal under section 18 of the Sarfesa Act is permissible against the order passed by the DRT under section 17 of the Sarfesa Act. Under section 17, the scope of inquiry is limited to the steps taken under section 13(4) against the secured assets. Therefore, whatever amount is mentioned in the notice under section 13(2) of the Sarfesa Act, in case steps under, this part is very important, in case steps taken under section 13(2), 13(4) against the secured assets are under challenge before the DRT will be the debt due within the meaning of proviso to section 18 of the Sarfesa Act. In case of challenge to the sale of the secured assets, the amount mentioned in the sale certificate will have to be considered while determining the amount of pre-deposit under section 18 of the Sarfesa Act. However, in a case where both are under challenge, namely the steps taken under section 13(4) against the secured assets and also the auction sale of the secured assets, in that case, the debt due shall mean any liability which is claimed as due from any person, whichever is higher. Well, three amounts. First amount, which is mentioned in the demand notice under section 13(2). In this case, that amount is 1.98 crore. Even the DRT in the implement order has observed that that is not the amount which is to be considered. Second amount is the amount if I challenge the notice under 13(2) and 13(4). In that case, I have to necessarily, my lord, follow the amount which is there in the demand notice on. That is the law. Third amount, my lords, that if I challenge both, if I challenge the sale also, auction sale also, as well as the 13(2), 13(4) also, then again I'll have to go back to the amount in the demand notice.
That main amount.
Yes, the main.
1 crore 90.
Yes, but if I challenge the sale, then I will only have to deposit on the
It will come
basis
down
of
to
the
half.
sale amount. No,
According to it,
on
will
the
come
sale
down to
amount.
half.
Yes. Now, in this case, my lord, admittedly, even the bank has said that the property was sold at 1.32 CR, 1.32 crores. My lord, the learned DRT has committed two errors of jurisdiction. First, it has held that 1.53 crore. That is the amount due. No, that is not the amount. It cannot be, because here I have challenged, my lord, I will show from the section 17 application that we had challenged the auction sale. And that property was sold by them for 1.32 crores. So the amount, the debt due should be taken as 1.32 crore. That is the first aspect of the matter. Second aspect, my lords, lordship has seen that not a line of my submission, nothing from the IA waiver has been considered. Where is the application, a judicial application of mine? But I do not want to produce. I can produce. There are orders of the Calcutta High Court. Same chairperson, my lord, has passed similar type of non-application of mine orders, my lord. High Court has remanded back and he has, my lord, done the needful. I do not want to get into that aspect of the matter. But today, my lords, prima facie, my liability is 1.32 crore. Just to clarify the issue, if your lordship will kindly have, my lords, the application, the page 34 onwards, which is the essay, my lord. Actually, what I have challenged, my lord. Now, this, my lord, at page 34, annexure 4, essay number 40 of 2024. This is the surface eye application, my lord, which I filed before the DRT Guwahati. And if your lordship will kindly come to page 41, the relief sought. Page 41. In view of the facts as mentioned above, the applicant prays for the following relief, that this Honorable Tribunal may be pleased to set aside the e-auction sale notice dated 21/2/2024 issued by the respondent bank. I have challenged the sale. I have not challenged the demand notice or the possession notice. In that view of the matter, my lords, the amount as per the Supreme Court judgment, which he himself as the learned chairperson has quoted, should be 1.32 crore. And my lords, the very purpose of filing the IA is that my prima facie ground should be considered. Nothing has been considered. It is as good as, my lord, not filing any application for waiver and straight away going and depositing the 50%. Then the entire purpose of filing the waiver application is that there should be some application of mine, whether this person has a case or not, to come to this appellate trip. Now, subject to whatever my learned friend has to say, my lord, that is.
May I please, Your Lord? Your Lordship, the DRT is a tribunal constituted under the special statute, Your Honor. And DRT is not a court, Your Lordship, subordinate to this honorable court, Your Honor. So they have passed the order stating that 50% amount will be deposited. That is written in the section 18 itself, that DRT has, as if I can read, Your Honor.
If you agree 50% of 1.32 crores, if you agree to that amount, then we don't have to go that far. Or else if you're not agreeing, then we will proceed. That he is submitting that 50% of the.
No, not 50%. I am entitled.
25%.
I am
Or
entitled
total
to 25%. No, complete waiver can never be there. No. The law laid down by Parliament.
25% of 1.30 crore. If you are
That is the-
agreeable
that
to
is-
that amount, then we can pass an order. Otherwise, we will proceed.
Or he can take instruction, and in the meantime, lordship.
Okay, you can take instructions there.
Your Lordship, it is written in the statute itself that 50%, the DRT can ask for 50%. So nothing, there is no error in the order itself, Your Lordship. Because it is strictly written, provided further that no appeal shall be entered in unless the borrower has deposited the appellate tribunal 50% of the amount of debt due from him. And whatever is stated, it has been properly stated how much amount he should deposit. So, in my humble submission, Your Lordship, this case is not maintainable.
Not maintainable.
Is not maintainable, Your
On
Lordship.
what ground?
Because DRT is a statute. DRT is itself there is an act itself, and according to that act only they proceed on it. So once they have gone to the DRT Guwahati under section 17, Your Lordship. So after that, they have filed an appeal before the DRT, and DRT has asked them to submit 50%, Your Honor. So that order itself is has come to an full and final order, Your Honor, Your Lordship. So revisional jurisdiction will cannot be entertained by this court because DRT itself is a complete statute.
But is it
Basically, DRT is not a.
Let him complete.
Basically, DRT is not a subordinate court of Guwahati High Court.
What you're saying comes under one statute.
Yes, but I mean to say that
this SARFAESI Act is a statute.
It's a special statute. It's a special statute. SARFAESI Act is a special
law,
statute.
yes.
Yes. So when DRT has asked them to submit 50%, Your Honor, that order cannot be challenged in revisional jurisdiction, Your Honor. That is why I said it is not maintainable. Because it is not a subordinate court, Your Honor, to the Guwahati High Court.
Okay.
Lordships are disposing the matter or?
No,
But then I would have to produce certain judgments. So Lordship, Malad just looks into one judgment. Malad. Hey, it is- But first of all, my response to the argument of my learned friend that DRT, is it his submission that DRT's orders are so final that they cannot be questioned anywhere?
that is a submission.
That can.
No, I said in
Very in clear words you have said.
I
This
don't
order is final.
in revisional jurisdiction, I
Then under which jurisdiction, my lord? The fact remains, Article 227 is couched very widely. It doesn't say courts. It says courts and tribunals within the jurisdiction. I cannot go to the Calcutta High Court. Just yesterday, my lord, Calcutta High Court has dismissed one case arising out of an order out of the DRT Guwahati. Calcutta High Court says that if your tribunal is Guwahati, go to the Guwahati High Court. DRT Kolkata, just like let us say, my lord, there is an appellate tribunal at Delhi. Matter arises out of Guwahati. Can I, my lord, go and file it in the Delhi High Court? They will throw me out. That is what he's saying is beyond understanding. And the other thing is that Article 227 is very wide power. Here we are.
That is what he has submitted.
Yes. And this is my response to him, what he has submitted. In law school, my lord, we were taught one judgment, my lord, 7-judge bench, L. Chandra Kumar. Entire supervisory jurisdiction is there. Thereafter, there are a number of judgments of the Supreme Court. There is Radhesham versus Chabinath and all. The crux of the matter is, if it is a judicial order of a civil court, then I cannot come under 226. However, I can always come under 227, whether it is a judicial order of a tribunal or of a civil court. That is why, my lords, we file here CR. In fact, it is only in our High Court, I think, that it is couched as CRP. In other High Courts, including Delhi, Bombay, etc., these are known as writ petitions, because these are essentially writs under Article 227. So 227, my lords, gives the High Court supervisory jurisdiction to correct and keep the tribunals within their bounds. Here is a patent case, my lord, of a failure of jurisdiction of the appellate tribunal, which dealing with an waiver application. And I will show, my lord, from the Bombay High Court judgment as to how a waiver application is supposed to be dealt with. Lordship will kindly have for a minute.
See, this case, your property is from Guwahati.
Yes.
And then your recovery tribunal is in Kolkata.
No, DRT is at Guwahati. Appellate forum is at Kolkata.
Appellate forum.
Yes. So if I go to Calcutta High Court.
Appellate forum is at Kolkata.
Yes.
Your recovery tribunal is at Guwahati.
Guwahati. Yes.
And then you went up to Kolkata as a
on
an appeal.
Because this is a statutory appeal.
Okay.
Yes. So, and against that statutory appeal, there is no further appeal or revision provided by law. So the only remedy in law is Article 227, because it's an error of jurisdiction. When the tribunal, my lord, fails to apply its mind to the subject matter at hand, it's a case of failure of jurisdiction. That is precisely what has been done. Now, if your lordship will kindly have the judgment that I have
on waiver.
On waiver, how to deal, my lord, with
this is the only court question now we have.
The only question.
Waiver, on waiver.
On waiver, and my submission remains that had the tribunal, the appellate tribunal, looked into my submissions, considered my case, at least for the prima facie aspect, then it would not have said 50% just like that. Because then in that case, my lord, why to file a waiver application? Let us go and file a deposit 50% and get it over. Your lordship will kindly have for a minute, my lord, because it's very important. Lordship will kindly have para 6, my lord. This is a judgment of my lord's former Chief Justice, my lord Justice Chandrachud, when he was in the Bombay High Court. My lordship will have para 6. Section 21 provides that where an appeal is preferred by any person from whom an amount of debt is due to a bank or financial institution or a consortium, the appeal shall not be entertained by the appellate tribunal unless such person has deposited with the appellate tribunal 75. Earlier it was 75%, now it is 50. 50% of the amount of debt due so from him as determined by the tribunal under Section 19. Under the proviso to Section 21, the appellate tribunal may, for reasons to be recorded in writing, waive or reduce the amount to be deposited under the section. The mandate of the statute is that ordinarily an appellant before the appellate tribunal must deposit 75% of the amount of the debt due as determined by the tribunal under Section 19. Parliament, however, in its wisdom, conferred a wholesome power upon the appellate tribunal to reduce the amount to be deposited under the section. The exercise of that power is a judicial power, which is further structured by the requirement that reasons have to be recorded in writing for reducing the amount to be deposited to less than 75% of the debt as determined by the tribunal. The appellate tribunal has proceeded in the present case on an erroneous conception as to its own jurisdiction. Learned chairperson has observed that at this stage, it is not possible to make any comment on the impugned judgment and order of the tribunal. Now at the stage when it considers an application for dispensing with the condition of deposit, appellate tribunal is not expected to render a final finding on the merits of the contentions urged in regard to the judgment of the tribunal. That has to await the final determination of the appeal, but it is a well-settled principle of law that even at that stage, the question as to whether a prima facie case has been made out has to be evaluated by the appellate tribunal. For the limited purpose of considering whether a dispensation should be granted, appellate tribunal has necessarily to evaluate as to whether a prima facie case is made out, and the reasons which are to be formulated have to be confined only to that determination. If the proposition which has been laid down by the DRT were to be accepted as a good law, then that would mean that a litigant who does not plead financial hardship is disabled from urging that the requirement of pre-deposit should be reduced or waived within the parameters laid down by the statute. That is not reflective of the legal position. In considering as to whether a waiver should be granted, both the elements of a prima facie case and the question of financial hardship would have to be considered by the appellate tribunal. Whereas in the present case, the appellant does not plead financial hardship, that is a relevant consideration which has to be taken into consideration and placed in the balance by the appellate tribunal. But that is not dispositive of the jurisdiction of the appellate tribunal. Appellate tribunal in its appellate jurisdiction is required to evaluate as to whether a prima facie case has been made out for the grant of waiver. Hence, with respect, we are unable to subscribe to the position as set out in paragraph 20 of the judgment of the DRT quoted above. Now, para 8, Malod, since the DRT has not considered the application for waiver in terms of the legal position as elaborated in the previous paragraph of this judgment, which is consistent with the provisions of section 21, we set aside the impugned order of the appellate tribunal and restore the application for waiver of deposit.
Before a division bench, I think.
Lordship. We expedite the so-and-so for a decision afresh. So it was, Malod, remanded back, Malod, with the direction
Not
that...
before a division bench.
Lordship. So this is for before Bombay.
Division bench.
So this is before, that depends on the roster system. Because here, Lordship will see writ petition. Writ petition, had it been a writ petition. Under 226, yes, it will.
Yes, sir, you have told, you have said just now, you have said that in some certain.
Yes, yes. Even in Delhi,
What
Malod.
was writ petition?
But in Kolkata, again, Malod, it is known as CO, Malod, civil order.
Okay.
I can place if necessary, but I do not want Malod today to.
Okay, there you have a point then. What do you have to say?
My humble says only this much, Your Honor, that it is very much clear in the section 18 itself that DRT can ask for 50% deposit of the amount, and that DRT has said to ask them to deposit 50% of the amount, and there is nothing illegal in that. No
Section
error has been
21
committed.
of which act has been referred to?
RDB Act. Malod.
Section 21.
Section 21 of the Recovery of Debts and Bankruptcy Act, which is same provision as, Malod, the 18 of the SARFAESI Act. Malod, the DRT is an appellate forum for both purposes, under the RDB Act also and under the SARFAESI Act also. If I go against an order under the RDB Act, then I also have to go in appeal there and under SARFAESI also. Same provision. At this stage, Malod, Lordship will kindly, Malod, issue notice, Malod, there is a private respondent also involved, who is the auction purchaser.
So we'll issue notice?
Lordship.
You want to stay now?
Malod, the matter has to be stayed, because if I do not deposit this 50%, then my appeal will stand dismissed, Malod, on the next day. So that is the difficulty. In the meantime, I shall take steps, Malod, from the private respondent, and my learned friend can file whatever objection he wants.
Lordship,
I'll go through section 18.
18, yes, sir.
You are insisting on section 18, emphasizing section 18.
Yes, sir, Lordship. It is clearly stated that, provided further that, may I read your Lordship?
Yes, please.
Provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50%. 50% of the amount of the debt due from him, as claimed by the secured creditors or determined by the debt recovery tribunal, whichever is less. It is very clear, Your Honor. So debt recovery DRT has rightly asked him to deposit 50% of the amount.
But provided also the appellate tribunal may, for the reasons to be recorded in writing, reduce the amount to not less than 25%.
Yes, Your Lordship, that is the discretion of the DRT. The DRT has not found any.
We won't go very far. Let's stay till the next date.
Lordship.
Only till the next date.
Lordship.
Then you can file your objection. Then if you have a point, then we will set aside the stay, vacate the stay order. You're a caveator.
Your
No,
lordship.
no.
No, caveat was not.
Normally, I would have opposed it, but.
Third learned counsel, Mr. A. Ganguly for the petitioner and learned standing counsel
No, panel, S Chanda,
and learned counsel, Mr.
S Chanda,
S.
Chanda.
Chanda for Central Bank of India.
No, these for respondents 1 and 2.
1 and 2. 1 and 2.
For respondent number 1 and 2. The appellant is aggrieved by the order passed by the order dated, which
Let
page
24
106, no?
Yes. 106. Date is 24/7/2025.
24/7/2025 passed by the learned appellate tribunal, Kolkata bench. Kolkata bench na Kolkata in connection with appeal capital D small y full stop number 765/2024. The application before the interlocutory application before the tribunal was for with prayer for waiver.
Waiver.
Of the, what amount is it called?
Waiver from making pre-deposit.
A waiver from making pre-deposit of the amount of rupees 1.32 crore.
No, lordship will not go into the amount, if I may suggest. Waiver for making pre-deposit.
Okay.
Under section 18, that part, lordship.
Waiver for making pre-deposit under, where is a prayer in the application?
Where
The
is there
section
at page
18
14?
of the
Yes.
act on to likhi diba surface act gute act to naam likhi diba in short the surface act for short likhi diba. Page, which page?
No, lordship can take it from the order of the chairperson also. He is written here, IA number so and so for waiver from making pre-deposit as required under section 18
Oh,
of this.
ठीक है sir. Oh, ठीक है sir. To for waiver for making pre-deposit as required under section 18 of the Hay Act.
Surface Act.
2002 within bracket Surface Act for short. The learned counsel for the respondent has laid, respondent number 1 and 2 has laid stress stating that it is mandatory to deposit, it is mandatory that 50% of the, it is mandatory to mandatory to make a pre-deposit of 50%. And the order was correctly passed by the learned tribunal. First off, the learned counsel for the respondent has prayed, has submitted that the order requires no interference as the order and the order correctly passed by the tribunal and the order requires no interference. Post of detail. The learned counsel for the appellant has relied on a decision of the Bombay High Court in connection with MS Sterlite Technologies Limited versus Union of India, reported in 2012 within brackets 113 AIC 636, wherein it has been held that paragraph 608. The learned counsel has also drawn the attention of this court to the second proviso. This is the second proviso.
Lordship.
Second proviso of section 18 of the Surface Act. To stop. It appears that the impugned order may be stayed at least till the next date of listing.
But second and third. There are two relevant provisos in this case, because the third proviso says that for reasons recorded to be writing, it may be reduced to 25%.
Second and third proviso. second and third proviso of section 18 of the SRPC Act. And then at least till the next date of listing. So we'll list it then. You file objection.
Look, notice has to go to the auction purchasing.
Yes, yes. Issue notice to how many respondents?
Look, no formal notice to him.
No, no.
And respondent number 3, registered AD, I'll take steps.
Petitioner to take steps to issue notice to respondent number 3 to register post with AD, returnable within 4 weeks. The post of as learned counsel for the respondent number 1 and 2 has appeared. No formal notice is required to be issued. Has appeared and accepted notice. No formal notice is required to be issued. Extra copies to be furnished. List accordingly.
Not the further proceedings in.
Yes, yes, for the proceedings of appeal number what?
Diary number 765 of 2000.
765 DY number 7.
It's at page 15, 15.
Appeal DY number 765 of 2024 is stayed till the next date of listing. That is. It order to answer it.
May I please allow? Well, otherwise, matter is very simple. The fact goes like that. I am the owner of a plot of land where one person and proprietorship firm built a building. His part he got, I have received my part. Thereafter, everything was okay. In the year 2010,
You are the owner of a plot of land.
So
you got your part and
it was a building was built by one builder.
yes.
So
builder took the other part.
yes, one part of the building has been received by the builder. I have received my own part, and in the map also that is described. Thereafter, my lord, in the year 2010, that builder agreed to sell one part room commercial building, 4 or 5 rooms, my lord, at the second floor of the building to a third party. I am not involved with that part because it is his part. I have no objection to that. But there were some discrepancy, there were some dispute for which that agreement for sale was disputed. For which, my lord, the builder instituted one title suit being number, my lord, TS 516 of 2022, which is still pending before the civil judge number 2. So, my lord, the main dispute between the builder and that third person regarding specific rooms, 4 or 5 rooms at the second floor. So, I was implicated as pro forma defendants in that case. My lord, may you kindly come to Annexure 1, page 11 of the CRP, the plain. Page 11, my lord.
This is what?
Plain.
Page 11?
Plain.
Okay.
Yes.
That suit between those two parties.
Yes. I have been implicated as pro forma defendant, being an owner, which is a regular exercise, my lord. So, page 11, my lord, the plaintiff is MS RB Engineering. Number 2 is Ripun Bhuya, who is the proprietor and the builder also. And defendant number 1, Pranab Jyoti Burman, who is that person with whom the agreement for sale was executed. 2, 3, 4, and 5 are the pro forma defendant, means the present petitioners before your lordship. Well, thereafter, when I wanted to sell and other.
You are a pro forma defendant number 3,
2,
4, and 5.
3, 4, 5. Yes, 2, 3, 4, 5. 2, 3, 4 are
Same family.
Same family. Originally, my father was the owner. After his death, it was I became the owner, my lord, of my part. Thereafter, my lord, I wanted.
And who is this BSK Builders?
That is our proprietorship firm, partnership firm, who is maintaining the building also.
Okay.
So 2 to 5 are us, my lord. Thereafter, my lord, when one part and room number specifically, my lord, 16, 17, 18 at the second floor was to be sold by me. And another part at the ground floor was to be rented out. So I applied for the Form 50 before the court. District judge and civil judge junior division I obtained before there is no case. But when the matter came to the civil judges, this matter title suit has been shown as pending. So when the record was brought, the Sirostadar verified it, and I personally met him and showed him that the dispute between those persons is on the second floor and specific room number is there. My lord may come to the schedule part, my lord, of the plane. That is, my lord, page 30 is the schedule of the plane.
Okay.
Page 29 is the schedule A, which is the whole plot of land. And schedule B is the specifically, my lord, suit land. Suit part actually, not land, suit part. May I read, my lord, page 30?
Yes, yes.
All that as shop room number 1, 2, 3, 4, 4A, 8, 9, and 10, measuring 3,308 square feet at the second floor of RCC building, name and style KM Plaza, which is situated over a plot of land. My lord. Tag number, patta number are same. My lord, this is specifically mentioned room number 1, 2, 3, 4, 4A, 8, 9, and 10. Now, my lord, kindly come to page, Annexer 8, page 54, my Form 50.
Page?
54. Annexer 8, 54 and 55. Two Form 50s were applied. 54, Annexer 8. And 9, my lord, 55.
54.
Yes.
Okay.
Here, my lord, the schedule I have mentioned, all that a commercial space measuring carpet area 990 square feet at room number 16, 17, and 18 on the second floor. So I have mentioned specifically my part, room number 16, 17, and 18. Now, if we come to the page number 55, space measuring, commercial space measuring carpet area of 1100 square feet at the ground floor. So, suit part is different, my part is different, although it is on the same plot of land. But, my lord, the Sirostadar asked me that as there is a case, so kindly submit a petition before the court. So, I have filed one petition before the court, which is at page, my lord, Annexer 4, page 45.
Okay.
I have submitted this application showing that my schedule is different, their schedule is different. So on a plot of land, a apartment building, there may be hundreds of flats. As because on a particular flat or room numbers is, if there is any case pending, that does not mean that the other part of the building and more specifically mentioned in the Form 50, that cannot be, my lord,
I understand.
help it. So I have filed this petition, but no decision was taken. Therefore, my lord, I have filed another petition, joint petition, including the plaintiff, builder, as well as myself, my lord. That is a page number 48, my lord. So for the satisfaction of the court below, I even filed one joint petition showing that the plaintiff has no objection, my lord. Page 48. Page 48 is a joint petition on behalf of plaintiff and the pro forma defendants. So plaintiff's signature is there. He also said that as because the schedules are different, but he does not have any objection. Now, my lord, if we go to the objection of the defendant number 1 also, against that person with whom the agreement for sale, he simply denied that in the plaint, against the plaint in the title suit, said that no, we are ready, we will pay against that part, and we will execute the execute and register the sale deed. So there is no counterclaim. So whatever happens in the title suit, that will confine to that schedule, schedule B, room number 1, 2, 3, 4, 4A, and 8 and 9. So other part, that cannot be any dispute. And trial court adamantly, my lord, no, did not listen to me, and no Form 50 was issued to me in spite of the joint petition. And thereafter, even that also, my lord, I filed one application before that Honorable District Judge, my lord. That is at page number.
So was there any order passed?
No, my lord.
Okay, but no, but form was not issued to you.
No. Form was issued with that.
No, there's a caveat.
Litigation is pending. So that cannot do the purpose, because the title suit may last for a long time. Thereafter, appeal may go on in the Supreme Court also. For that long
you
period.
went to the district judge.
Yes, my lord. One application has been submitted. That is at page number 52, my lord. But instead of deciding anything, my lord, the learned district judge simply forwarded the matter to the civil judge. Then civil judge forwarded the matter to the Sirostadar. And thereafter, my lord, this Form 50 has been issued with the note that litigation is pending. So being an owner also, as well as the pro forma defendant, for just for formalities, I cannot do anything on my own part. So I am not able to sell.
So
I am not
what is your
able.
prayer now?
My lord, my prayer is to dispose of, if possible, today itself, because the plaintiff has no objection, to with a direction to the civil court as well as the Sirostadar to issue Form 50, because specifically I have mentioned the room number, my part. So comparing the schedule also, it is different. So against this two Form 50, 16, 17, and 18 room number, and another is at ground floor. The floor is also different, my lord,
Yes.
at another. So the Sirostadar can issue me Form 50 against this part, my lord. So a direction would simply, my lord, required.
Can be given, I think.
My lord.
Whom have you made the opposite parties?
My lord, for formalities, actually, I have made the plaintiff as well as the defendant number 1. But as because the plaintiff, I have shown, my lord, joint petition has been there. Against the defendant number 1, before the trial court, he is included as respondent number 3 here. But there is no counterclaim. Even if we assume that something would happen in the title suit, he will get, or the builder would get. What would be the, my lord, the area of portion is specifically mentioned in the Schedule B, not in my part, not even in the part, other part of the builder also. So, my lord, one direction would suffice that to issue a direction.
Where is the prayer? Let me check the prayer.
My lord. Page 8, my lord. Two numbers of Form 50 litigation certificates shall not be issued in favor of petitioner oblique pro forma defendants against the two Form 50 A and B has been, my lord, marked.
Okay. Third learned counsel, Mr.
D.K. Nath.
D.K. Nath for the petitioner. For the petitioners, number 1, for the petitioners, DK number 1 लिख दिया, SCLE लिख दिया. BK Builders and Enterprise, number 2, Srimati Tun Borgotogi. Number 3, Anish Borgotogi. And number 3, Anish Borgotogi. Full stop. The respondents in this case are MS RB Engineering, Sri Ripun Bhuya and Sri Pranabhuti Borman, respectively. Arrayed as respectively, arrayed as respondent number 1, 2, and 3, respectively. It is submitted that the petitioner and the respondent And the respondent number 1 and 2, no?
My lord.
You are the partners.
Yes.
For
No,
off-duty Burman,
I am the owner. Present petitioner.
I understand.
1 and 2 are the builders, and 3 Pranabjyoti Burman was the party
That
against.
Again, who had a dispute?
Yes,
in-
with plaintiff come respondent number 1 and 2.
The petitioner and the respondent number, petitioners and the respondent number 1 and 2 are shareholders of a building.
KM Plaza.
Hmm?
KM Plaza. Building name is KM Plaza. My lord,
A building.
the schedule is at page 29, my lord.
The name of that building,
KM Plaza, page 30, my lord. Second line.
page 30,
Yes.
second line. Oh,
Yes,
K
K
Plaza,
M.
capital K, K-A-Y, capital. Also all of space D, M, capital M, space D, Plaza. So capital, huh? Located at Beltola,
Ganeshguri, my lord.
located at Ganeshguri.
Yes.
It is submitted that the petitioner was the petitioners were the original owner of the plot of land, and the respondent number 1 and 2 as builders became shareholders after building, after construction of the building. To stop both the petitioners and the respondent number 1 and 2 have been also taking care of the building on a partnership basis. A dispute arose between the respondent number 1 and 2 with the respondent number 3, and a title suit was filed by who has filed the title suit?
Respondent number 1 and 2. Builder.
Respondent number 1 and 2 against the respondent number 3, registered as TS number 516/2022.
Yes. That is pending before civil judge number 2. Senior division.
Who stopped the suit property in the title suit is clearly described in the schedule
Schedule
B
B.
of the plaint, which is also mentioned here in below.
Page 30, my lord.
Page 30 schedule B likha hai, huh? This title suit is pending before the civil judge,
Senior division number 2.
learned civil judge senior division number 2, Kamrup Metro. At present, the petitioners are willing to sell
My lord.
sell their share of some their share of some rooms
My lord.
and shop houses.
Commercial rooms.
Their
Rooms
share
and
of
shops.
some rooms and commercial enclosures to the proposed purchasers.
My lord. One is for sale, another is for let out. Sell
Sale and rent
Yes.
to the proposed purchasers, and that will be tenants. The petitioner is unable to proceed with the sale and rent of the scheduled property of the property belonging to the petitioner, as a Form 50 was not issued in favor of the petitioner. Form 50 was issued in favor of the petitioner with a caveat. Huh?
With a observation that litigation is pending.
With a note by the shadow study relating to litigation in title suit 516/2022. So it is submitted on behalf of the petitioner that this has been erroneously inserted in the Form 50 by the shadow study, as the petitioners are
Page 54, madam. 54 and 55.
petitioners have clearly mentioned through their applications before the learned civil judge as well as the learned district judge that they are willing to sell or rent 990, huh?
Well,
900,
first one is 990.
990 square feet at room number 16, 17, and 18 on the second floor of the building.
And second one is
Standing over Doug number 407, covered by KP Patta number. KP number it will be, not KP Patta, no?
KP.
KP number 28 at Dispur, Moza Bel, at Dispur, Moza Beltola, under Dispur Revenue Circle. The another plot with carpet area, another space, another commercial space with a carpet area of 1100 square feet at the ground floor of the building at Doug number 407 at the same here, over the same, in the same building is proposed to be let out on rent.
Right.
Rent, no?
Right.
Is proposed to be let out on rent, full stop. It is apparent that the aforementioned commercial space rooms are not the rooms described in the schedule B of the plan, which is the property in dispute between the respondent number 2, respondent number 1 and 2.
With
with the respondent number 3, full stop. The plaint is marked as annexure 1. Annexure 1.
Yes, ma'am. Another one is the plain.
One of this petition, and the Form 50 issued from the office of the civil judge, senior division number 1, is marked as annexure 8.
8 and 9.
And 9 of the petition. As the petitioners are also arrayed as pro forma defendants in the title suit, they are unable to sell the suit property, unable to sell their own property, as well as let their own property out or let their own property on rent. Full stop. The note of the sheriff study on annexure 8 and 9 clearly reflects that the litigation is pending in the name of the applicant with the scheduled land in connection with TS 516/2022, which is pending in the court of the civil judge senior division number 2, Kamrup M. Full stop. I've also considered the application filed by the petitioner jointly with the plaintiff.
Well, plaintiffs.
Plaintiff. Stroke respondent number 1 and 2. Which is marked as annexure. Which annexure?
6.
Which is marked as annexure 6 of the petition. It is clearly mentioned in the Annexure 6 that the RCC building, namely KM Plaza, is standing on the Schedule A land, but the suit is pending only against Schedule B commercial space. Full stop. If the Schedule B of the land is now next parallel. In this case, in this matter, if the Schedule B of the land is compared with the schedule described in Annexure A10 9 of the petition, it is manifestly clear that the suit property is not similar to the enclosures described under Annexure 8 and 9 of the petition. Full stop. Thereby, the trial court where the title suit number 516 of 2022 is pending, is directed to verify and compare the suit property along with the property of the present petitioner, who is also arraigned as pro forma defendant, petitioners who are also arraigned as pro forma defendants in the TS in the aforementioned title suit, and the office and the trial court may delay its office to issue Form 50 after proper verification of the suit property vis-a-vis the property described under Annexure 8 and Annexure 9 of this petition, which are the earlier Form 50, which are the earlier Form number 50 issued to the petitioners stroke pro forma defendants of the of title suit number 516 of 2022.
Well, just my prayer, my lord, in the earlier sentence, Schedule B land has been described. It may be Schedule B commercial space.
Schedule B commercial space earlier sentence.
Earlier, 2 or 3 sentences earlier.
Wherever land comes, we will mention it as commercial space. In
Because
terms
the
of
whole-
the above observation, this petition stands disposed of.
Well, time frame may be given if possible.
Hmm?
Time frame may be given.
Within as expeditiously as possible. I will correct it.
Public.
Just I have added it as expeditiously as possible.
Public.
Item 3 or item 3.
Dismiss কৰি দিওঁ নেকি? আগতেও অহা নাই। নাই আগতে দুটা অহা নাই। SP চৌধুৰী আছিলে নেকি? নাই। Parties, leader parties are not represented. So earlier on 2/9/2025 as well as on 29/5/2025, parties were absent on call. So list this matter. List this matter after puja vacation positively for hearing. Failing with appellant and learned counsel, Mr.
A.U. Ahmed on behalf of K. Bhattacharya.
A.U. Ahmed is present on behalf of learned counsel, Mr. K. Bhattacharya, representing the respondent number 1. Both the parties have submitted that there is no element of settlement and the case may not be referred for mediation. To stop. As there is no element for settlement, list the matter in its usual course.
Lordship, LCR has been received.
Okay, list the matter for hearing. All the respondents are present.
No, Lordship, respondent number
Okay, we will decide it later. List the matter on after puja vacation. List the matter on puja vacation. After puja vacation.
I'm like.
Item 5. Settle mediation.
My lord,
They are willing to
fix
settle.
for mediation, my lord, look adalat may be fixed,
It
my
will be
lord.
better, Lordship.
It
Look
will be
adalat.
better, my lord.
But
On 13th, I think.
are you ready with the documents and everything?
Yes, Lordship.
Then
It was already
fix it
fixed
on
for him.
local on 13th. I think we have
Yes.
local. Both the parties have agreed to settle the dispute amicably in the local. This matter before the local scheduled to be held on local to be held on 13th September.
My lord.
Lordship. Must apply.
Item 6.
We have filed our affidavit of opposition today. We have served a copy as well. My lord, matter will be fixed for admission hearing on 18th, my lord. For respondent 6.
Learned counsel, Mr.
B. Sakya.
B. Suke is present for the petitioner. Learned counsel, Mr.
A. Ahmed for respondent number 6.
K. Ahmed is present for respondent number 6. Learned government advocate, Mr.
T.R. Gogoi.
T.R. Gogoi is present.
1 and 3, Lord.
Respondent number 1 and 3.
Lords.
All the parties have filed local number and everything.
Yes, my lord.
List this matter after puja vacation.
My lord, can it be on 18th? There is an urgency, my lord. My it's an
On-
title
on?
18th of September.
18 on fine. Yeah, it's admission. No,
No, 19.
19. Then maybe in the motion last week, maybe. 19. On 19.
Much about it.
Item 7.
Your lordship has heard the matter, my lord, on the last occasion.
I've heard a matter.
But last occasion, the matter had come.
Okay.
If you hope your lordship remember,
Oh, no,
that landlord and tenant.
Huh?
Landlord and tenant matter, my lord. Lordship, I want to further say.
Oh, the notice here, yes.
Yes.
Notes are here, so it doesn't matter. I have noted down everything.
Okay. All thing, lordship, see the prayer of the suit may be seen, my lord, the title suit, which is at page 184.
This is an IA.
The IA for stay, my lord.
IA for stay.
Yeah. Because the records have to come, my lord. Normally, whether we pay for the records to be here. And it is disposed of in merit of the case. So there are.
You are praying for stay.
Yes.
You're praying.
Till the next date, my lord, because the records call for whatever because they have paid for 2 grounds, my lord, on bona fide requirement and default of rent. Bona fide requirement as such, in my respectful submission.
Okay, I have heard. I was not convinced to stay.
Yes, very correct, very correct. So my question is that let the scanned copy of the records may be sent, my lord. And maybe a small date, maybe 1 week or 10 days, whatever your lordship prefers, my lord. The matter may be decided on the merit of the case.
We'll dispose it off.
On the merit, my lord.
On merits, we'll
On
dispose
merit.
it off.
I have no objection to that, my lord, because I'll avail if lordship pass the order against me, my lord. I'll recourse to the other remedy, my lord.
Yes, sure.
But But question is that, my lord, lordship may see the two grounds, my lord, bona fide requirement and default of rent. Default of rent, maybe I'm paying at the old rate, but I'm paying rent regularly, my lord, till date. Because they have annexed the rent receipt at the last, showing that, my lord, I'm paying rent throughout, my lord. And number one is the bona fide requirement. The bona fide requirement, my lord.
I don't know, but I remember vividly, I was not at all willing to stay the matter.
Yes.
I was not at all willing to stay.
Yes, yes, very correct, very correct.
Yes, yes. So we'll call for the scan copies of the record.
Record, and lordship may pass the order thereafter.
Yes.
We are objecting to the grant of stay at this stage, my lord.
No, I am not willing. You don't have to
Records may be
object.
called for, we are not objecting, but as to the
I remember I was not willing to stay that day.
Very
itself.
correct.
Otherwise, on the same day, I may pass the order.
Yes, yes.
So we'll call for the scan copies. We'll
My lord.
dispose it off.
My lord.
Sure date may be granted. my lord.
Yes, yes. No. Maybe after vacation, because I do not have. There is
Because trial court is waiting for the order of
On
this
the-
court and they are
on
not
the-
proceeding the
immediately after the
execution
vacation.
case.
You see, this matter has to be dealt into in depth.
Yes.
So I don't think we have time. This 2
But just
weeks-
immediately after vacation, my lord.
Immediately.
Immediately.
We don't have time in these 2 weeks. Call for the
But
trial court.
Trial
record.
court is not proceeding with the execution also, so without any stay. So that has already prejudiced the right of
You
the.
want a stay?
No,
Then call for the scan copies of the trial court records of, this is rent case, no?
Rent case, my lord.
What is the original case number?
title suit number 2 of 22.
Title suit number 2 of
2 of 22.
2 of 22, on data DDR. 15th October, list the matter in the admission column on 15th October.
Obliged.
Matter may be disposed of.
We'll dispose it of that
That
day.
may be
Then we mention, my lord, matter will be
disposed
on
of.
15th.
Because
For
execution.
consider, for disposal of the matter at the stage of admission.
My lord. Obliged.
Continue.
May please the lordship, this matter may be referred to the local lordship.
Okay. What about the other side?
The side is already a talk of compromise is going on.
Okay,
lordship.
okay. You're for the insurer.
Yes, I'm appearing on behalf of Mr. T. Kolita.
Okay, if you're for the insurer, then we can easily refer to local adalat. Learned counsel, Miss
M. Saikya lordship.
M. Kalita, present on
M.
behalf.
Saikya.
M. Soikia. M. Soikia, present on behalf of learned counsel, Mr. T. Kolita, has submitted that this matter may be referred to Lok Adalat as there is a scope of settlement. List this matter on 13/9 before the Lok Adalat.
Obliged, lordship.
Item 9 for this under.
May I please? There are concurrent judgment against me. Decree of eviction. I am the defendant in the original suit. Suit has been filed by the plaintiffs for declaration of their right title interest and from eviction from the suit land. Our case is that in the year 1989, we have purchased the land from the predecessor of the
You are
plaintiff.
a defendant.
I am the defendant. We have purchased the land from the predecessor of the defendant on a consideration of rupees 12,000 per bigha. But due to the ban of the registration at that time, sale deed cannot be registered at that time. But we are in possession from 1989. And accordingly, in 1989, our name has been recorded in the Chitha mutation. In the 2025, our possession has been declared in a proceeding under section 145 CRPC. In 2006 also, they have filed a suit for the declaration of the right title interest and from recovery of the possession from us. That suit has been decreed in favor of the another first appellate court also affirmed the judgment of the lower trial court. In this case,
You were in possession since 1980.
1989, let's say, for more than 12 years. So our substantial question of law at page 12 also. Whether the
We'll go to the appellate court's final order.
at page yes, page 28. Page 41, Lord. It starts from page 41.
You are a defendant
I am the defendant.
and then you are the appellant.
Yes, I am the actor.
Here, You were a defendant and then in the title suit you were a
Plaintiff
appeal.
has filed the suit, their suit has been decreed,
Yes,
and we filed a first appeal.
first appeal,
And that was dismissed.
dismissed.
And again, we have filed the second appeal.
Okay. TA number 1 of 2015. So we'll go to the decisive issue.
Decisive issue is lordship regarding the question of limitation lordship. Because we have been in possession of the suit land since 1989 and suit has been filed in 2006 lordship. The learned first appellate court as well as the trial court has committed error while deciding that we have been possession in the suit land from 2005. Thus, there is an evidence lordship that we have been possession of the suit land from 1989. Our name has been mutated lordship, and in the 145 proceeding, suit land has been possession has been declared given to us lordship, and on that basis we have been in possession from last 12 years. Issue number 3 lordship, page 50. Whether the suit is barred by limitation.
Yes.
I have perused the pleadings of the parties. It is the case of the plaintiffs that they are the owner and possessor of the suit land. They have been possessing the suit land since lifetime of their predecessors. From the avertments made in the plain, it appears that according to the plaintiff, the cause of action for the suits arose on 27/9/2000, the date of institution of the Miss Case number 50/2000, and on 8/3/2005, the date of the final order of the said Miss Case, and on 30/3/2005. When the defendants made an attempt to dispose the plaintiffs from the suit land on 30/3/2005 and on 21/4/2005. Further, it is seen from the record that plaintiffs came to know about the mediation of the land in the name of the defendants and the raised objection before the assistant settlement officer in the year 2000 and got the record of right corrected by deleting the names of the defendants in the respect of the suit land. Then Ghafiruddin Mondal, our predecessor of interest of defendants, filed petition before settlement officer to provide Miss Case number so and so on 27/9/2000, and the settlement officer, after inquiry and hearing, reversed the order of assistant settlement officer and passed order on 8/3/2005, declaring the possession of the defendants over the suit land and put them in possession. This being the position, and the plaintiff subsequently filed petition for amendment of the case, because earlier they have filed a suit only for their right title interest lordship, but afterwards they have filed amendment petition inserting the recovery of position, because suit has been filed on 2006. But as far as the amendment, they have been dispossessed from the suit land in the year 2005 lordship. That has been subsequently amended. That is absolutely false lordship. That being the position, and the plaintiff subsequently filing petition for amendment in the case for the alleged disposition would show that the plaintiff brought the suit well within the period of limitation, and this issue decided in favor of the plaintiff lordship. Because I have been in position for more than 12 years lordship. There is a limitation in my name. And there is
Please sit down. I'll just read the other issues.
Yes, lordship.
Please sit down.
And one more thing, lordship, suit has been decreed against, there are 13 defendants. Again, defendant number 7, who has expired during pendency of the suit. That has not been substituted, lordship, and suit passed against a dead person is nullity in the eye of law, lordship.
Defendant number 7.
Defendant number 7, lordship. And in the case, lordship, although they have,
Maybe they were not aware of his death.
they will aware, lordship, because it is a duty of the plaintiff to substitute it. And no leave has been granted, because state has a party, defendant number 13 and 14. They have to obtain leave of the court under section 82. That has not been taken, lordship.
Please sit down. I'll read the other issues. You have claimed adverse possession?
Yes, Lord. No, I'm claiming the suit, Lordship, because
Then
the court has
how
the,
you will claim it
No,
at this stage?
court has the power, Lordship, to issue if no prayer has been made
No.
regarding adverse possession. And the suit is not maintainable, Lordship, because it has been filed beyond 12 years, Lordship. For any suit for declaration of right title on basis of possession, Lordship, that has to be filed.
They're filing the suit on title or by right of inheritance.
Lordship, but they have failed to produce any document, Lordship, regarding their, Lordship, may kindly come peruse case 52, Lordship, issue number 6 and 7.
I have read it.
Hi, Lordship. Because in order to prove their title, they have only exhibited some land holding certificate and some mutation, Lordship. Mutation is not the title, Lordship. And one mutation regarding Nasibullah Munshi, Lordship. As far as their person, it was their grandfather, Lordship.
They have
Because
right
they have
title by way of inheritance, and that defendant number 13's name also appears. Or not, I mean plaintiff, that granddaughter's name also appears. Plaintiff number 13, I think, not defendant number 13.
Suit has been filed by the sons of the one Gulabuddin Munshi and Gulab Haq, Lordship.
You had a case, if you had prayed for adverse possession, what are your substantial questions of law? First one cannot be taken out of.
Three and four maybe, I'm not sure. Because the question of limitation and whether the
There's no limitation.
Lordship,
There's no limitation. They're claiming the title
no, there is a limitation of 12 years, Lordship. There is a limitation of 12 years for institution of the suit.
no, but you have not claimed adverse possession.
There is right, Lordship, but
No, no.
on the admitted facts,
Have any case. We'll fix it for another date. I'll not frame any substantial question of law.
that may be given after vacation, Lordship. Because I have been appearing on behalf of Mr. G.B. Bhamik, Lordship, the senior counsel.
This matter after puja vacation.
How like?
In this, in the office note, there is some confusion, Your Lordship. There's an office note dated 19/8/2025. It is not related to this case, Your Lordship. Perhaps it is related to RSA 51/22.
Yeah, it's in our is 52.
Our is 52. It is not related to this
Office
case.
51 is not.
Well, it is a
What are you saying?
Lordship, the office note is not related to this case. The parties reflected in the office note are not of this case, Your Lordship. Because the flag B that is given with the office note, there are two flags. In flag B, there is an IA civil number 979/22 that is connected to some other RSA number 51. It may be sent back to registry, Your Lordship. This office note is not of this case, Your Lordship. Some other case. It may be sent.
Counsel Mr. B.J. Mukherjee is present for the appellant and learned counsel Miss
D. Pathak.
D. Pathak is present for respondent number 6 and 7.
Yes.
It is submitted by the learned counsel for the appellant that the office note dated 19/8/2025 is confusing as the RSA number 51.
51, Your Lordship.
52/2022 is
52
not.
is this one,
52 is
but
our-
the RSA is in relation to 51, Your Lordship, not this one actually.
because there are two flags with the office note, it is written 52. That is why it is put here, because with the flag B, your lordship, in that flag it is 51. So perhaps while typing, they have written 52 and tagged it here, your lordship.
Okay. In flag B, okay.
Flag B, your lordship, there is a letter from
Because the flag B which has been referred to in the office note is relating to RSA number 51 of 2022. But this case is, but the instant case is RSA number 52 of 2022. Place this matter before the registry for rectification.
Yes.
My lord, in this case, I am appearing on behalf of respondent number 1. My lord, I have misplaced the copy of the memo of PP.
Okay.
May I pray that it may be taken up on next week?
Tomorrow, my lord, I'll give copy today. Tomorrow, may take it.
Tomorrow? Not possible. Tomorrow we have 33 cases.
No, there, I'm paying next week. No?
Next week also won't be possible.
Then,
We have already fixed so many cases, and today also many will be left over. Many
then
cases
as
will be
per your
left
lordship's convenience.
after vacation.
It is admission. Next week, any date, my lord, next week, any date.
This is not admission.
Yes.
Order 41.
Order 41, because appeal is not admitted. Any date next week, any date. We'll try. If not possible,
Next week. List this matter after 1 week.
date may be given, otherwise.
No. Registry, I actually registry.
25 matter not admitted, Mala. This is why. New case.
No. Actually, registry has requested me not to give dates.
It is a, like motion and
No,
like.
why they have requested me not to give dates? Because they are unable to accommodate. There are so many cases being pushed up together in the same month.
After 1 week. Date
1
may
week,
be-
yes.
Date may be given.
Registry to list this matter after 1 week.
Much.
Item number 30 for orders.
Lordship, certain respondents have been added in the main appeal, my lord, and we were directed to take steps. We have taken steps, my lord. As per office note dated 16/7/2025, the notices on 5, 6, and 7 have been served.
And the rest not served.
5, 6, 7 served, my lord. Those were the new respondents. However, respondent 8 is there, but we could not ascertain the address of the respondent number 8, newly added. As such, my lord, my prayer is that we may be allowed to take substituted service by newspaper, my lord. And my lord, for respondent numbers 1A, B, and C, those were there from earlier. But what has happened, my lord, notices have been served, nor unserved notice nor AD card has been received back. So 1A, 1B, 1C, it may be deemed to be served. Because we have taken,
Steps to register AD.
Yes, registered AD as well as postal. It's reflected in the Lawazima order dated 19/8.
Lawazima order dated
19/8/24.
It's not even 1 month. It has to be 1 month, then we can,
No, my lord, 1A213 we had taken earlier on. It's reflected in 19/8/24 order. Lavazim
okay,
order.
okay. Let the matter be listed on the 4th week of September. Let them pass the order. Lawazima.
My lord, but for the respondent number 8, my lord.
Yes, yes.
Substituted
Fresh-
service
Yes, yes,
by newspaper.
yes, yes. So this, they will pass the order, Lawazima, why should we take the pains? Let them pass the order.
But for newspaper.
Yes, yes, for respondent number 8. Yes, sure. Learned Counsel, Mr.
K.R. Borua.
K.R. Bova is present for the appellate. The applicant may take steps to issue notice to respondent number 8 by substituted
Substituted service. Through newspaper.
through well circulated news daily. Office note dated. Where is the office note that?
16/7/25.
Office note dated 16/7/2025 reflects that notices have been served to a newly implemented parties, respondent number 5, 6, and 7. List after petition?
Yes. But date may be fixed on it.
No. It will very returnable within 4 weeks. Substituted very returnable within 4 weeks. Not returnable actually within 4 to be served within 4 weeks. To be served within 4 weeks. Returnable na like news daily as to be served within 4 weeks.
Yes, please give me the. Lordship, here substitution is complete, Lordship, and cross objection service is complete. So maybe take to the main record. And the
What service?
cross objection, Lordship. This IA implement is complete, Lordship.
Okay.
Service is complete also. And
This can go for final hearing, Lordship. After vacation, a date may be given.
this cross objection may kindly be admitted, Lord. Cross objection 21/18 may kindly be admitted. Cross objection 21/18 may kindly be admitted. And the take with the main appeal.
Where is the cross objection number?
21/18.
It will not. It will not.
Copy decision.
And here also service is complete, Lordship. So it may kindly be checked with the main appeal P2717.
Or we will take together.
Yes, Lordship. Both our appeal and their cross objection can be heard together. A date may be fixed, Lordship.
Main appeal is
After vacation.
32717. 32717.
And service of notice on whom has been complete?
We were complete.
Or
In the both the appeal and
we will pass a common order.
yes.
Yes, Lord.
Parties are represented. Learned Counsel, Mr.
A.R. Agarwal.
A.R. Agarwal is present for the claimant.
Clement.
Clement cross objector.
Huh?
Clement cross objector.
No.
Common
Okay,
order
we'll tag it
to
together.
claimant.
So we are giving a common name. Is present for the claimant, and Learned Counsel Ms. R.D. Muzumdar is present for the insurer.
Oriental Insurance Company.
For the insurance company, New India Insurance.
No,
Company.
Oriental Insurance.
Oriental Insurance Company. As pleadings are complete and as the trial court records are before us, the matters are tagged together for hearing. List this matter for hearing after puja vacation.
Both cross objection and the main appeal.
Everything.
Take together.
Yes.
Lordship, can a date be given?
Date?
Any date after vacation? On November delay hobo. Because if a date is fixed, Lordship, we know that on this date is coming. Highly obliged,
Because
Lordship.
we have too many cases.
Yes.
No, Lordship, no. Highly obliged, Lordship.
Item 70.
May it please, your lordship. I am appearing for the respondents here.
His first appearance.
My lord,
First
this
appearance.
First appeal, my lord, it was admitted and stay was granted.
So
Now
I have
they are,
filed an
file
application for vacating
modification of
the
the
stay application.
If stay goes, then nothing will survive. So let
Because your
the
lordship,
matter
what
go
has happened in the
hearing.
matter, I entered into an agreement with the defendants that I am the purchaser of the suit land, and accordingly the consideration.
This is for admission and will dispose it.
No,
of.
it has already been admitted.
Oh, yes, yes. This is
it-
for hearing then.
No,
hearing,
it may be listed in the admission column.
No, no,
and
it has already been admitted.
Then it may be kept at the order in the orders column only, and a date may be fixed. And accordingly, the
No, no. See, we have to dispose it finally. So it has to be fixed for hearing because I think it cannot be, this order has to be, we'll have to go deep into the case. Then only we can pass a proper order.
then your lordship, a date may be fixed. There is some urgency.
Vacation after hearing some.
After Puja vacation, a date may be
We can
given.
fix a date.
Yes, yes.
And my lord, I think record.
We have the records.
The records are here.
It appears like to be the for trial court records.
Yes, yes, yes.
Trial court record. We have the records. Learned counsel, Mr. S.K. Ghosh is present for the appellant and learned counsel, Mr. S. Doctor is present for the sole respondent. As the records are before us, list this matter for hearing on date 13 November.
Much of.
Obliged.
Please, lordship. Lordship, it is already admitted and the substantial question was already formed. But the TCR is not called for lordship. It is a RSA.
Okay.
The
Not
TCR is to be called, no lordship.
call for the trial court
Lordship,
record.
as the respondent has entered appearance, therefore, after receiving of the LCR, let the matter may be fixed for hearing.
Two records.
Two
Call
records.
for the.
Title suit and title.
Call for the original records of TS number 22/2016 and TA number 9/2022. List this matter after Puja vacation.
Obliged.
After records will come, then we can fix it for hearing.
Obliged.
As per last story, lordship, I need some more time to file the objection, your lordship.
Nobody is present for the appellants, I think. Learned counsel, Mr.
Hey, that's
Appellants are not represented today. Learned counsel, Mr. F. Deka.
A Das, sir.
Mr.
A Das, your lordship. For the sole respondent.
Item number 19, no?
19, your lordship.
Or Mr. A. Das is present for the respondent and has prayed for some more time to file eviction.
Objection, your lordship. Let it be on 24th of October.
Let's just 24th on
October.
Let's just matter on 24 October.
Much obliged, your lordship.
The English counsel BNAT has requested me to take an adjournment today due to some.
However, your lordship, as per tech report, Lawazima report, the service is not complete. I am for defendant number 1, 2, and respondent number 1, 2, and 3. There are other respondents.
Let it be come after vacation.
After vacation.
Obliged.
Learned counsel, what is your name?
P. Sharma.
P.
P. Sharma.
P. Sharma on behalf of
BNAT.
Learned counsel, Mr. B. Nath, representing the appellant, has prayed for adjournment. Learned counsel, Mr. S. Deka.
J. Das.
J. Das is present for respondent number 1, 2, and 3. List this matter after Puja vacation.
Deeply obliged.
Item 22.
May I please, your lordship? In this case, I am led by Senior Counsel A.C. Sharma, my lord. As per office note dated 21/6/25, notice upon respondent of 1 to 3, my lord. LC has come, other side is absent.
notice has been served
Yes.
to both the respondents.
Both, there's-
And this is
1 to
also
3.
already admitted. We fix for hearing then.
Yes.
Where is the office note?
21/6/25 minutes. Respondent of 1 to 3.
Learned counsel, Mr.
DJ meeting.
DJ Media is present for the appellant. Office note dated 21/6/2025 reflects that notices have been served to all the respondents. As the trial court record,
Yes, madam. LCS now.
as the trial court records are before us, list this matter for hearing after puja vacation.
In the usual process.
List this matter for hearing in the usual process.
Much of.
You have a stay?
Yes, in the
IA to interim order shall continue till the next date of listing.
My lord, in this matter, I am the respondent, my lord.
Hmm.
This matter, my lord, this case has arisen out of a, my lord, agreement, my lord, for sale of a certain property, my lord, which was thereafter, my lord, refused by the, my lord, vendor. It has come for orders only, my lord. So, my lord, may kindly, my lord, fix it for hearing, my lord, because the lower courts records are here. So, lordship may fix it after the vacation, my lord, on a fixed date.
Appellant is not represented today. Learned counsel, Mr. G. Chaudhary is present for how many respondents?
Only one.
He is present on
In
behalf.
fact, I am the respondent, my lord.
You yourself, you
I
are the respondent.
myself, my lord. Today, my lord, in this case, I am led by Mr. Sattar, but today he is not there. So, lord, I am here to apprise your lordships, my lord.
Okay. Mr. G.
This was a
Chaudhary-
case where I am myself am the victim, my lord, in this case, my lord. A huge amount of money has been taken. Thereafter, my lord, the property was not sold to me. And now, my lord, after, my lord, I am the decree holder also, my lord, here. I had filed a suit for specific performance that were allowed. Against that, my lord, this appeal has come, my lord. Lordship, my lord, keep it as part heard also, my lord, if your lordship desires, my lord, and my lord, because I have already submitted it. This is the basic facts of the case, my lord. And
Can be kept as partner on request by advocate, but let it come for hearing. I'll fix a date.
yes,
Because it's not for hearing. That is why we'll fix it for hearing.
yes, my lord, yes. Ultimately, when the records have come, my lord, the lower court records are here.
Mm.
So it is any day it's a hearing actually, because it's an appeal ultimately, my lord. There's nothing further to do.
Mm.
So lordships may keep it further and fix it for hearing, my lord, if a lordship desires, because this is the facts of the case. And my lord, on the basis of all evidence and everything, it has been proved, my lord, that there was an agreement. There was a refusal to accept. Even the money was, my lord, my lord, proffered to pay, my lord, at the time of the trial before the court also, that if you accept it today, I am ready to pay.
They
That
have
also it was
obtained a
denied.
stay or something?
No, my lord.
No, they have not
No,
obtained a stay.
no, my lord.
So don't worry.
My lord, my lord.
This just matter, as the records are before us. G. Chaudhary likhla, no? Learned counsel, Mr. G. Chaudhary is present. So for respondent, na lage, they are nije respondent. So as the trial court records are before us, list this matter for hearing. You want a date?
Let it be late date, my lord, it will be easier, my lord. Then it will ultimately, my lord, I will also ensure.
11 November?
My lord,
11 November.
I am deeply obliged.
Item 24.
Please, Lordship. Lordship, in this RSA, TCR has already been received, Lordship. And if your Lordship may, TCR is already received, Lordship.
Okay.
And if your Lordship may peruse office note dated 3/4/2025.
It's served.
AD duly signed and stamped by the sole respondent.
Already admitted earlier.
Lordship, appeal
Oh,
is admitted.
yes, yes.
Admitted.
RSA, okay. Substantial questions of law have been.
Yes,
Okay. AD duly received stamped by the sole respondent. Okay. Yes. Learned counsel, Mr.
W. Hawk.
W. Hogg is present for the appellant. Office note dated 3/4/2025 reflects that notices have been duly served to the sole respondent. As the trial court records are before us, list this matter for hearing after in its usual process.
Item 25.
May I please, Let me kindly pass me for time being, Lordship. I am not in this case. MSP Bhattacharya is appearing. She is on legs, Lordship.
For the time being?
Item 26.
May it please your Lordship. Your Lordship, in this case, respondent number 1 and 3 has already entered appearance, Your Lordship. But as regards respondent number 2, Your Lordship, dusty services awaited, Your Lordship. We haven't received a report. Otherwise, Your Lordship, there is delay of only 2 days in filing the appeal.
My lord, in this appeal, we are raising some preliminary objection. My lord, they have filed this appeal in violation of the provisions of law. They have filed appeal under section 173 of the Motor Vehicles Act.
But the other respondents are yet to appear.
Yes, services
No,
not
my lord,
completed, Your Lordship.
it is a preliminary objection we are raising. The appearance of the respondent is not related with the problem. Problem is that, my lord, at the time of filing the appeal, they ought to have filed, deposited the amount required as per provisions of law. Appeal should be filed with the certificate of deposit of the
Deposited statutory amount,
required.
that is rupees 25,000, Your Lordship. That has already been deposited. Rupees 25,000, that is a statutory amount that has been deposited.
Yes, that's what I am submitting, my lord, that statutory amount they ought to have deposited. We are not, we don't know whether they have submitted.
Did we have people with it?
Yes.
This is true. This is 25,000. Without deposit, appeal cannot be filed, Your Lordship.
Appeal cannot be filed without deposit.
So then we will await for other appearance of the other respondents.
My lord, one respondent has already entered appearance on honor or the driver.
1 and 3 has appeared, Your Lordship. As regards.
So all have appeared.
Yes.
Only
Respondent
2
number
days
2.
delay, then we'll condone the delay.
Now, 2 days delay, regarding delay, we have no objection, my lord. It is up to your lordship.
You're for the claimant?
We are for the claimant.
And anybody for the driver, insurer?
Driver, insurance.
We are the insurance company.
You are
You are driver.
insurer, driver
Driver.
and owner. So there are other contributory negligence? No.
No.
Okay. Then we'll
Let me
condone the
respond
delay.
to-
Delay may be condoned. You don't object. My lord, the amount deposited by them may be allowed to be withdrawn by the claimant.
That cannot be
Yes,
withdrawn,
Papa.
Your Lordship. For that, appeal has to be admitted, and interim amount that may be considered at the time of admission, Your Lordship. Appeal is yet to be numbered.
Provision of law does not say so. When the amount has been deposited as the requirement of the law, that may be allowed to be withdrawn by the claimant.
That is the statutory amount, Your
Let the
Lordship.
appeal
That
be
has to be
registered.
withdrawn.
Statutory amount.
Let the appeal be registered.
Yes, Your Lordship.
Condone
For
the
that, appeal
delay
has to be
first.
registered.
Learned Counsel, Miss P. Bothagur, he is present for the appellant. From us, Learned Counsel, Mr. Yes, your name?
J. Mullah.
J. Munda is present for OP number 1. For my Learned Counsel, Miss,
Experience.
for whom?
For respondent number 1.
It's okay.
Yeah.
Miss? Huh? ANH form is present for respondent number 3 and Learned Counsel, you are for any respondent? Sitting, no. Who is for respondent number 2? Nobody. Notices are yet to be served to
Yes, Your
respondent number
Lordship.
2.
Dusty report is awaited, Your Lordship. In respect of respondent number 2, we can take steps at the admission stage also, Your Lordship.
My lord, before the tribunal also, as there is insurance coverage, that's why normally in the case covered by insurance policy, the owner and driver, they don't turn up.
Let the notice be served on respondent
We are
number 3.
denying liability, so your
Yes.
involvement
Let
is there.
the
So
notice be
they are
served on
necessary.
respondent number 3.
Yes, Your Lordship.
Let the appearance be complete.
Note, earlier step was taken against this. So my lord, this matter may kindly be then referred to the Lozima court, my lord. Lozima court will give the opinion on that basis. Your lordship will proceed.
Notice has been issued to respond.
We had
number
taken
two.
steps to
Yes, yes.
Please awaited your
Yes.
lordship.
That's why step was taken properly. Long time has gone. Now the matter may go to the Lozima court. Lozima court will give the opinion regarding drawing presumption of service of notice. Because my lord,
Lordship, we
long-
are yet to receive the dusty report from our company, your lordship.
Service report on respondent number 2 is awaited. List the matter on
After vacation.
after vacation. After vacation. Let the notice be served.
Yes, your lordship.
my lord, the problem is there. The claimants, they cannot be left dry and high, my lord. Because my lord, the award has been awarded.
Stay.
No,
Lordship, we have
no,
filed state station, your lordship.
No.
That appeal has to
Yeah,
be numbered.
you're free. You're free. You can take the money also. We have not admitted the appeal as yet. We have not admitted the appeal.
Yes, my lord.
You can take the claim amount also.
Execution facility. All right, my lord, my lord.
Okay.
May it please the court. As pursuant to the last order of this honorable court, we have served notice upon the respondents. And if it pleases the court, the matter may be listed for admission hearing after puja.
Can be.
The office note dated 22/4/25 makes note of the service.
Only 2 respondents.
Yes.
Learned counsel, Mr.
S. Barwa appearing on behalf of Mr. R.J. Das.
S. Borwa, on behalf of learned counsel, Mr. R.J. Das, representing the appellant is present. Office note dated 22/4/2025 reflects that notices have been served on the respondents number 1 and 2. As this is relating to, have we called for any trial court records?
I believe we have.
Huh? Nine.
Stand corrected.
I think records are not called for. Do you want the records?
I believe that'd be prudent. Yes.
But you have given next sufficient copies. Will you require the records? All the copies are there.
Okay, yes. I guess
If it
we
is
don't.
sufficient, then
Sure.
list it for hearing. It's up to you.
After puja.
You suggest whether we'll call for the records or we will list it for hearing.
List for hearing.
Hearing.
Yes.
Registry to list this matter for hearing. After puja vacation.
Obliged. And the ad interim injunction continues now.
Injunction की जो आवश्यकता नहीं है. Interlocutory execution night. No, there's no injunction matter. Hearing होगा ना तो why? Do very good. Kati
Unless there was an ad interim injunction in the last order.
Yeah.
In the IA,
No, there is no order of injunction. No order of injunction. No order.
was 23/10/2024.
No. No order for injunction. Maybe there, no such order for injunction. Okay, then we'll list it for orders, then you can place your submission then.
Was for hearing or? I'm a bit confused. I'm very sorry.
For interim injunction, you'll have to list it for orders.
What was the last order 23/10/24?
No, there's no interim order. No order for injunction or status quo, no such order. Only issue notice.
That's the last line. The opposite parties are restrained from representing themselves as the president and secretary of
More to nine dekha. I to nine dekha. Last line of which paragraph?
my lords, it's the fifth paragraph, my lords.
Oh, just a moment. Considering the registration of the okay, all right. Is this matter for hearing likhila, no? The interim order dated, the interim order shall remain in force till the next date of listing.
Much obliged.
I hate to live. CRP to. CRP no, I to live.
Much obliged. I apologize for the confusion, my lord.
No, it's okay. Do it a club to live.
My sincere apology for not being present in item number 19, Lordship. I was online in court number 6.
I don't know what order I have passed.
Lordship has picked the matter in the month of October. I have.
Huh? Non-appears given likhidilo. Appellant, okay. Your name?
K. Kolita.
K. Kolita is present for the appellant.
Hello.
Yes.
May please, your lordship, at my instance, matter is listed, lordship. What happened in this case, lordship? Husband filed one divorce proceeding against me, lordship, that is pending. In that proceeding, lordship, one order was passed on 13/8/2024, lordship, almost 1 year back, lordship, to pay me rupees 10,000 per month as penalty, like, lordship, and 30,000 as a litigation cost, lordship. Against that, my learned friend preferred the present petition, lordship. There is no stay order, lordship. So since then, lordship, not a single amount has been paid to me. That's why I have mentioned the matter before your lordship. In fact, I filed one application before the learned trial court again also, and one order was passed to pay, but till date, nothing has been paid by the petitioner, lordship. That is my grievances, lordship. 10,000 by penalty like per month, because I am no income, lordship. Petitioner has, respondent has no income. She is the wife, lordship. Husband is a serving person, lordship. He is serving as a branch manager, Aditya Birla Health Insurance Company, lordship. So at least still disposal of this petition, lordship. So let him pay that 10,000 as a maintenance, lordship. Interim maintenance. That is only interim maintenance, lordship.
Bank manager.
No,
10,000.
Branch manager, lordship.
Branch manager.
Yes.
Lordship,
Only 10,000.
the trial court, your lordship, did not looked at the matter in proper perspective, your lordship, because my income is shown to be 65,965, and expenditure is 65,000. So only 900 rupees remains. So the order was passed to pay 10,000 rupees per month.
That will be decided on merit,
Just
lordship.
a moment, please. And the litigation cost of 30,000 one time. But that order was passed without application of mine, your lordship. That is why this order was assailed, your lordship, before this honorable court. And moreover, your lordship, the respondent hearing, she is a graduate and she has She's a makeup artist, your lordship, and she 28 lordship, only for release of 50% budgetary amount.
Now?
Now it's next item.
At two.
The minor personal difficulties, I shall vote for the one to the.
What correction do you want?
My, that is that for the annexer one, that is page number 7, my lord. Your lordship's order dated 1/9/2025.
What is the technical error?
Technical error, that is, my lord, that is,
Typographical error.
yes, my lord,
Error, typographical error.
typographical. error.
Where?
That is, my lord, that is at page 8, my lord.
Page 8?
8. Petition number 481 to 2025 under section 153 is necessary to clear that. And order 6 rule 17. That is in the cost title is there.
Okay.
Then, Your Honor.
Which order 18 likhi dile. I don't know. It came out as that.
And
I'll get it corrected, don't worry. Where?
as document, and then, my lord, at paragraph 2.
Where, which paragraph? Which paragraph of your petition?
Two of the order sheets.
No, in your petition?
My petition is, mention is, my lord, that is at paragraph 1 and 2.
Paragraph 1 and 2? Okay. Third, learned counsel, Mr.
B.N. Sharma.
Sorry?
B.N.
B.N. Sharma. Learned counsel, Mr. B.N. Sharma for the applicant So it is submitted that in
Order dated 119.
that that error has crept up in the order dated 1/9/2025 in the civil revision petition within bracket IO bracket close number 366 of 2025 full stop. There was an inadvertent typographical error in para 2 on the last line, i.e.
Then last but as document number 1 at page 70, that is document number 4. Yeah,
The
it
plain-
should be the document number 1.
i.e. the plain marked as document number 4 at page 16 should be corrected as document number 1
One.
at page 16. Full stop. Also,
And
para number 6 of the order dated 1/9/2025 of the impugned order
Dated 28/7/2025.
dated of the order dated 1/9/2025.
Instead of 27/5/2025.
Typing the impugned order as 27/5/2025, it ought to be typed and corrected as 28/7/2025.
25. Then in my petition, a clerical mistake was there. That the document number 1 has been stitched as a document number 2. Document number 1 should be the plaint. That both the plaint and the document number 1 and document number 2 has been stitched as written statement. 2 written statement has been stitched by the advocate's clerk.
In the order dated 1/9, next paragraph, in the order dated 1/9/2025, para number 1 of petition number 481/2025 under section 153 is required to be incorporated and corrected before order 6 rule 17 read with section 151 of the CPC as in document number 10, i.e. page 64 of CRP within bracket IO bracket close. The application number 481/2025 was filed under section 153 and order 6 rule 17 read with section 151 of the CPC. CPC, CRPC, no, CPC. Full stop. It is further it is further submitted that in petition number CRP 1 IO within bracket IO stroke 366 stroke 2025, there was an inadvertent mistake by the advocate's clerk and the document number 1, i.e. plaint of plaintiff stroke respondent was stitched.
16.
Written statement of defendant stroke petitioner instead
It
of
should be
plaint
plaintiff.
of plaintiff stroke respondent in CRP within bracket IO bracket close petition full stop. It is submitted that the same may be allowed to be allowed to stitch the plaint document number 1 by removing the written statement of defendant stroke petitioner. Full stop. It is further submitted that the cause title of CRP within bracket IO bracket close petition at page 2 petition number 481/2025 under section 153 and within inverted commas is not typed nor written in cause title due to typical mistake, typographical mistake as such under section 153 may be allowed to be inserted with order 6 rule 17 read with section 151 of the CPC 1948 in the said cause title of the petition. I do not find any meaning in that last sentence.
Which, my lord?
And also cause title CRP IO petition number 2, petition number 481 under section and is not typed nor written in clause. I don't know what What are you trying to say? I cannot understand. That last line,
Last.
all jumbled up. I cannot understand. What are you trying to say?
That by removing the written statement of the defendant number, first title of CRPI.
No.
At page.
And also from end also. Last page 4 last end also. First title CRP number. There's no
CRPIO petition
sentence.
and first title CRPIO petition at page number 2, petition number 481. That in documents number, that is in the document number.
No. Please correct the sentence. What are you trying to say? I cannot understand. I'm not going to document or anything.
That in the petition number 481 2025, that is page, my lord, that is in document number 10, we have mentioned categorically that section, that is under section 153 also.
Last sentence that you have mentioned in the earlier paragraph also.
Yes, also.
It's okay. I'm trying to help you out actually. But if that meaning I cannot understand that sentence. I've considered the submissions, all the errors are to be corrected and rectified. And this order will thereby form a part of the order dated 1/9/2025.
Yes, ma'am.
Of CRP number
366.
366 of 2025.
2020. CRPIO.
The error of the advocate clerk is also to be rectified and corrected.
Master.
In terms of the above observation, this petition stands disposed of.
Master.
I can give you. Read visible.
May I please be moved? May I please, Lordship, this is a prayer for withdrawal of the 50% amount amounting to rupees
We
7
don't
lakhs.
have any objection, Lordship, but subject to the deposit of an indemnity bond.
For
I am for the respondents, claimants and
applicant, claimant, and has filed his application with prayer for withdrawal of the
7 lakhs 55,000.
entire 7 lakhs.
Yes, 7 lakh 50%.
Withdrawal of 7,55,840 deposited by the
Claimant number
applicant.
1, Lordship. By claimant applicant number 1, mother of the deceased.
By the appellant before the registry of this court, full stop. The applicant, who is claimant number 1, stroke claimant number 1, Sheila Jaswal,
Yes, yes.
is allowed to withdraw the aforementioned amount from the registry of this court on her executing bond and on being properly verified by the registry. In terms of the above observation, this application stands disposed of.
Lordship, in the main appeal,
It will main appeal to yes. Yes.
I am for respondent 1 to 4.
claimants have entered appearance. Respondent, notice of respondent number 5 was received by his wife, but LCR has not been received yet.
So only reminder service is complete. Reminder for LCR.
Okay. Notice date, office note dated 9/9/2025 indicates that notices have been served to the respondents.
Complete.
Number R1, R2, R3.
R4. I am for 4 claimants, Lord.
And R5. Same family, no? R4 and R5.
R5 is, R4 is same family, Lordship. R5 is the owner,
Owner of the vehicle.
owner of the vehicle.
Okay. Issue notice or no, issue reminder to,
For LCR. Please.
forward the trial court records. List after puja vacation. Item 29.
In this case, I appear on behalf of respondent number 11, 12, 13, and 2. 14 has expired, but since the other representatives are already there, so substitution is not necessary. But LCR was called for, that has not been received, ma'am. The service is complete.
Okay. LCR is called, trial court record is called for is not received, issue reminder, list the matter after puja vacation.
Let me kindly fix the date, madam. 16th or 18th, madam.
16 of.
Deeply opposed.
Harry, it will litigation, learned counsel, you are for whom? Appellant is not represented, learned counsel, Mr.
A. Iqbal.
A. Iqbal is present for R1, R2.
R3 and respondent number 2.
R1, R2 and R3.
And 2.
R1, R2 and R3.
And respondent number 2, my lord. 1, 1,
Okay,
1.
okay, okay, and respondent number 2.
Oh, please.
Need be pleases, your lordship. On the last occasion, they have filed the affidavit tomorrow itself, your lordship. That was not bring to the records, your lordship. Kindly a short date may be given, your lordship, for final hearing, your lordship. This
Learned
matter is
counsel,
for
Ms.
transfer
P. Das is-
petition.
Learned legal aid counsel, no?
Legal aid
counsel, Ms. P. Das is present for the petitioner, and learned counsel, Mr. J. Abbas is present for
Also responding also.
the respondent, sole respondent. Push up the objection.
Yes, objection.
They have filed their objection
The
tomorrow.
objection is not on record. Registry to place the objection on record. List this matter on, when do you want?
Tuesday, your lordship.
Tuesday by
18 will be better.
Yes, your lordship.
for admission.
For admission, your lordship, final admission hearing.
It is
Deeply
September
obliged.
for admission.
Deeply obliged.
Item 31.
My pleasure. Your lordship, this is a transfer petition filed by the petitioner husband seeking transfer of two cases which are pending in
Husband?
by husband.
Divorce case?
No, two cases are already pending in the family court, Kamru. So, and two cases are pending in the Durham district. Your lordship,
My husband for transfer of?
two cases, that is absent criminal case number 242/2022, which is pending before the principal judge family court, as well as absent civil case number 1068/2023. Both are pending in principal judge, before the principal judge family court, Kamrup. And beside that, two criminal cases are also pending in the Durham district, your lordship. That is, one is CR case number 223/2022, and one Miss TV, that is 122/2020.
So total how many cases are pending?
So there are 4 cases are pending. In total, 4 cases are
Two cases are pending in Kamrup and 2 in Durham.
2 cases are pending in Kamrup district before the principal judge family court. We only seek the transfer of to that 2 cases to the Durham district, and should be tried in the same forum.
My lord, I am for the wife, my lord. What happened, my lord? I have filed a criminal case, that is, my lord, maintenance case against my husband. I have a 5-year-old baby also. And that case is pending before the family court.
Just a
Kamrup.
moment, I'll just hear him out and then I'll come back to you. So why do you want the cases to be transferred to Durham?
Because both the parties comes from the locality which nearby Mongol.
Wife stays in Durham.
Wife stays in Kamrup, but in Kamrup rural, it is far easier. It is it is nearer to Mongoldoy district rather than Kamrup metro.
Oh, this is Cape, okay.
In Mandagatar, The particular place is Mandakata. Which is geographically much closer to the court of law.
And any other ground?
Nothing, we have an interim player also.
No, on this is the only ground because she stays closer to the Dorong than to Kamrup. Any other ground to transfer these two cases?
The overlapping nature of the of this proceeding made it legally and practically expedient, and they be heard by the one court to avoid the multiplicity of the litigation. Then contradictory findings may be there.
So
Inconvenience of
the
parties.
husband has filed how many cases? How many cases has the husband filed?
Husband filed only one case.
One
That is
case,
for the
divorce case.
restitution of conjugal rights. That is pending before the principal judge, Kamrup Metro.
Restitution of conjugal rights.
Conjugal rights. Out of the matrimonial dispute, 4 litigations have been raised out. The maintenance case is pending before the Kamrup Metro, and the complaint case, that is under section 498 and 34 of IPC, as well as the domestic violence case under section 12 of Domestic Violence Act, they are pending in the Mall. So it is an intentional harassment.
So one, that restitution of conjugal rights is in Dorong, Kamrup.
In Kamrup.
And which one? Another one in Kamrup?
In Kamrup, absent criminal, case number 242 of 2022.
2022.
2020. And complaint case which is pending, which is also pending, that also in 2022, and Ms. TV is also in 2020.
Yes, what do you have to say? She has a baby.
I have objection, ma'am, because my learned friend, my lord, did not disclose clearly, my lord. What happened, my lord? I have filed finally a, my lord, maintenance case against my husband for the maintenance of myself and my baby, and which is pending before the family court Kamrup. And subsequently, husband filed a restoration petition in the same court, that is family court Kamrup. And another 2 criminal cases pending, because when I was staying in my husband's house in the district of Dorong, so that criminal case jurisdiction falls to the Dorong district. So I am compelled to file there. So this case is pending there, and these 2 cases, my lord, within the jurisdiction of family court. Now, my lord, I have some problem because I cannot, my lord, very safely can visit that Dorong district, my lord, the husband district, my lord. And that family court is very easy, my lord, for me. And within very short time I can come. And both the cases pending here. And the maintenance case, my lord, it may be run, my lord, whole life also. Suppose somehow I remarry and marriage is not dissolved, my lord. So whole the life I have to meet that place, my lord. It will very danger for me. And my lord, my learned friend saying that he's a husband, he's the problem. The problem suffered by me, my lord. I have no sufficient financial my lord, capacity also. And my lord, the financial hardship, one of the ground. Another ground, my lord, safety and security concern, my lord. And another ground, my lord, the responsibility of health condition of my child, my lord. And another ground, my lord, the husband's petition filed with malified intention, my lord. He may be harassed anytime at any moment, my lord, in his own place, my lord. And my lord, the pending case though is there, but regularly I cannot be visit there because in 498A and DB case, my lord, on certain particular day I will go and it will be finished. But my maintenance case will run because my daughter is only 5 years. So I have objection, my lord. His petition may be dismissed. And another important ground, my lord, my learned friend jointly filed, my lord, because one case is in criminal nature. That is, my lord, 125 maintenance case, and another is, my lord, that, my lord, civil nature. How my learned friend has filed this petition, my lord, under section, my lord, here 24 of the CPC, my lord. Both case cannot cover. And on that ground, petition itself will be dismissed, my lord. Because criminal case and civil case, both cannot file under 24.
Absolutely.
And criminal case, my lord, 407 of CRPC. So jointly they have filed. No, this is not system.
All the cases come out from the
So on that ground, petition may be dismissed.
Section 24 only in civil cases you can file.
And your lordship, geographically,
I'm dismissing the petition.
My lord, I'm appealing for the state of Assam. They have even implemented the state, my lord. So, since they have implemented us, so my advice is after I've heard both sides. So what they can do, both sides can sit down and solve the problem. In fact, instead of harassing the courts, they're going to every possible court.
Yes.
And they have even made the state of Assam party.
Very correctly.
And what they can do next time, my lord, in this order, when dismissing the case, can give them leave that they can go and try and compromise and settle the thing in the family court. And effort should be made to withdraw the criminal case. Because there's a baby also.
Yes.
So, and these kind of things I'm taking very seriously, the state. And they should not have involved the state.
Yes.
This is very serious, my lord. And since a baby is involved, they should compromise and all the cases, if possible, should be withdrawn.
Yes.
This can't go on forever, my lord. Every judge in this, in the court should be harassed, my lord. Every day they will come up with something new.
Yes, yes. Transfer petitions are like that. Yes. Learned Counsel, Mr.
H. Alam.
Our Learned Counsel, Mr. H. Alam, for the petitioner, for the petitioner who has filed this for application under Section 24 of the Code of Civil Procedure CPC, for short, within bracket, to transfer FC criminal case number 242/2022 under Section 125 of the CRPC, and FC civil case number 1068/2023 under Section 281 of the Mohammedan law from the Court of the Principal Judge Family Court to Family Court Kamrup Metro to Mongoldoy, to the Mongoldoy Court, to the District of Dorong, Mongoldoy Court. Full stop. Heard Mr. Anuddin, Learned Counsel for the respondent number 2, and Learned Government Advocate Mr.
KK Bhattacharya.
KK
Bhattacharya, for
Bhattacharya,
respondent number 1.
For the respondent number 1, full stop. It is submitted by the Learned Government Advocate that the petitioner has harassed the government by impleading the government as a party to this proceeding. Full stop. On the contrary, the Learned Counsel for the respondent number 2 has raised serious objection for transfer of the petition. Full stop. It is submitted that the respondent number 2 is mother of a 5-year-old minor child. Full stop. If the aforementioned cases are transferred to Dorong district, there will be several safety and security threats as she is apprehending threats and danger from the petitioner's side. Full stop. Moreover, the proceeding in this court is of such a nature where the respondent number 2 in this court, in the family court, is of such a nature where the respondent number 2 has to continuously appear for the maintenance case. Full stop. It is further submitted that the case for restitution of conjugal rights has been filed with Malafide in order to avoid payment of maintenance. Full stop. The petitioner, the Learned Counsel for the petitioner, on the other hand, has submitted that there are too many cases, and to avoid multiplicity of proceedings, all the cases may be tried in the same district. Full stop. Moreover, the residence where the respondent number 2 resides is geographically closer to the district of Mongoldoi, and it would not be convenient for the respondent number 2 to commute to the court of the principal judge. Whereas, on the contrary, it would be much easier for the respondent number 2 to commute to the Mongoldoi court in the district of Dorong, as her residence is nearer to Dorong district, and her residence falls under the under Kamrup rural. Full stop. Under Kamrup rural, under the district of Kamrup rural. Under the Kamrup rural, no? I have considered the submissions at the bar with circumspection. Full stop.
My lord, another section also, another submission, my lord, both case not covered by that section.
It is quasi civil. 125.
Yes.
Maybe
Yes.
that section 24 may cover. You never know.
Yes, yes, my lord.
Although it is criminal or
I have considered the submissions at the bar with circumspection. I find force in the argument of the learned counsel for the respondent number 2. Full stop. I have considered the submission that the respondent, I have considered the fact that the respondent number 2 has also respondent number 2 is mother of a 5-year-old minor daughter, and she has also to take care, and she has to take care of her daughter. Full stop. I have also considered the submission that it is much convenient for the respondent number 2 to travel to Guwahati, and there are no security issues in Guwahati, whereas the respondent number 2 is terrified to travel to Mongoldoi as the petitioners and his family members reside in Mongoldoi. Full stop. It is further submitted that the cases pending in Mongoldoi court are under the Domestic Violence Act and under section 498A of the IPC, and respondent number 2 is not required to travel travel frequently to Mongoldoi in pursuance of her of the cases pending at Mongoldoi. Full stop. In view of my foregoing discussions, at this juncture, this petition with prayer for transfer of FC criminal case number 4242/2022 and FC civil case number 1068/2023 stands rejected.
Congratulations.
32. This appeal challenges the order dated 7/9/2024. In this case number 75 of 2023, where the appellant was grant the limited visitation right to his only daughter, Lordship. Lordship, our limited prayer is that Lordship direct the respondent to allow the appellant to visit his only daughter twice in a month. It may be on Saturday or Sunday.
Didn't you try before the family court?
Lordship, the family court has already passed an order given only the limited visitation right to the appellant, Lordship, in the court premises during the day, during the date fixed by the Honorable Family Court, Lordship. They have another 2 cases. One is FC.
Lordship will find out at page 17. Para 5, my lord. Upon hearing the petitioner and the respondent, it is held that the respondent shall produce Miss Ishita Deka in the court on the day of her appearance in the cases pending between the sides, and the petitioner can meet Miss Ishita Deka, my lord, that is the daughter, in the court premises on that day.
Yes, Lordship. They only allow the appellant to meet his daughter in the court premises during the date fixed by the Honorable Family Court. But after passing this order, the appellant only once meet his daughter, lordship. The respondent makes some lame excuses like due to her school, classes, tuition, she is not able to appear, lordship. And being the father, lordship, he just want to meet his daughter outside the court environment, lordship.
Low. And I would have, as a government advocate, considered if the amount was low. The reference court rightly doubled it and they took the money happily and they did not show any protest at that time.
Protest also,
Yeah.
there has to be some protest while
Yes.
taking the money.
Under the law, on that ground, if they had protested, they get a ground to appeal to the High Court. They have not protested. They didn't show-
See, you try after puja vacation. Me, you cannot convince.
After
After the. Okay.
I'm appearing for respondent one. He's appearing for.
Learned counsel, miss?
F Intaz, lordship.
F Intaz is present for the appellant. Learned counsel, Mr. K.K.
K.K.
Bhattacharya.
Bhattacharya.
Learned government advocate.
Yes.
Mr. K.K. Bhattacharya is present for respondent number.
Respondent number one.
Oh, one.
State of Assam. Yes.
For the respondent number one, state of Assam.
I'm for respondent number 2, lordship, and after
Learned counsel, miss?
R. Devi.
R.
Devi.
Debbie is present for respondent number
2.
2. List this matter after puja vacation.
I can 35.
35 similar, lordship.
Similar, same case. Same land, same
Okay,
case.
then same.
Okay.
Eke na likhi diba.
Item 36.
Lordship, there are three areas, your lordship. It is for the substitution of the legal heirs of the appellant. During the pendency of the second appeal, your lordship, the appellant had expired. Your lordship, may kindly take up 1223 first, your lordship.
1223.
1223, your lordship.
1223.
This is a delay condonation petition.
Yes, 1223. Yes. You have any objection?
Also, one submission I have.
Uh.
After going to the IA, lordship, basically when the
1223.
yes, your lordship.
What kind of submission?
Submission in the sense, lordship, they have submitted para 5, your lordship, peruses. They have said that the death certificate and next of kin certificate, which usually in IAs like substitution, they used to annex it, but it's not been annexed. That is the only thing I find, that is the only difficulty. The death certificate and the next of kin certificate has not been annexed, though they have stated in the statement. But it's up to the lordship, that is the only thing. Because while writing, passing the order also that otherwise is kept on records, the death certificate and the next of kin certificate. Just to make sure that other day no other legal heirs. That is because they have given a statement, but that statement is also.
What is the certificate will fix another date?
Lordship, we will bring it on record. Yes, that is.
It's for your good.
Yes, also that is the only thing. Otherwise, I have
List this matter after puja vacation.
a date may be fixed, lordship.
It's the reason.
Kindly a date.
On 16th.
Deeply obliged.
16th of.
Deeply obliged.
Item 37.
Please, your lordship.
Hmm.
So this IA is for condoning delay
Hmm.
of 19 days in filing the
Issue
connected.
notice, issue notice.
What?
Issue notice.
No, notice has been issued, my lord.
Hmm.
Now today, my lord, if my lord peruses the office note, my lord, in respect to respondent number 1 SA, 1 SAW, it was done by AD card as well as the usual. And usual, my lord, will kindly see who has received. And on behalf of respondent number 1, Kha, Ga, and 3 were received by respondent number 2, who stays together. Who respondent number 2 is the uncle. And in respect of 1 SAW, address was not found, and process server report in respect to 1 Gha and Cha has not been received till date.
See, let the notice be served. Let the notice be served.
Yes, my lord. But my lord,
And you see, if you want notice to be served, or if you want to resort to order 5, rule 9(5), then send to registered AD, that will be easier.
no, I have sent, my lord. It was by AD.
Now let it be served to all of them. Only a few has been served.
No, my lord. Substantial respondent has been served. My lord, may kindly come to the cost title. My lord, may kindly come to the cost title. Kindly see respondent number 1. Ka, Kha, it has been served. Ga served. Gha not served. Sa and 1 cha and sa not served. 2 and 3 they have been served. And primarily because, my lord, because these are ladies when they must have got married and they have shifted to some other, they are in some other places now after being married. Because this is a suit which is date back to 1993. And primary, my lord, the respondents 1, 2 and 3. The primary respondents has been served, my lord.
One, all of them have been served.
Yeah, 1, my lord, 1 ka, 1 kha, and ga. They have been served. Kha,
She's a woman.
unga, sa, and cha. Look, they have not been served. The ladies have not been served. Otherwise, all the major respondent number
Yeah.
2 and 3 they have been served.
Most of them are married.
Yes, most of them are married, and because of
Legal heir of Ramcharan.
yes, because of which probably they have not been. All these Ramcharan Das sons, my lord, they have been served, and number 2 and number 3 they have been served. My lord.
You want me to condone the delay? Ex parte?
My lord, delay.
How many days delay?
19 days only, my lord. If
19
yes,
days.
my lord, and the delay happened because, my lord, I had an operation, my lord. I was entrusted with a brief, but because I had a gallbladder operation and there was death in my family, my lord, because of which some delay had happened, and because I have enclosed all the documents, my lord. The primary respondents, my lord, they have been served. The ladies have not been served only.
What is the limitation period?
Limitation period is 90 days.
Huh? 90 days.
90 days.
one short date. I'll pass an order. Let them, whether they'll come or not, I'll pass an order.
Yes.
One short date.
But Milord has seen Milord the office note.
Yes, yes.
2, 3 they have received. For who has received on behalf of the mail
Yes, yes, they have
members.
received.
Yes.
That's why I'm asking for a short date. Instead of Hariam, let me give you a date, I'll pass an order.
Yes.
Meanwhile, you take steps
Yes.
to the answer, and that this address is not found correct, that lady is
Only one.
insufficient address,
Yes.
so you give the sufficient address.
Yes.
Heard learned counsel, you were underwent gallbladder operation.
Yes, sir.
Heard learned counsel, Mr. NBP Singha. It is submitted that the notices to the prime respondents have already been served, as indicated by the office note dated
2/8.
28/2025. Full stop. I have also perused the office note. The process server's report reveals that notices have been served to respondent number 1 co 1 for 1 go 1 saw SSO, comma respondent number 2 and respondent number 3. First steps may be taken to issue notice to the other respondents. List the matter after vacation or before vacation.
And before vacation, if Milord.
Vacation or I got last of all a date.
Yes, any date.
Portion date or DD? 24th September.
Okay.
So please take steps.
Yes, Milord.
Then I'll pass an order.
Yes. Oblige.
Item 38.
May I please, Your Lordship? Lordship, in respect of respondent number 2, 3, and 4, this service is complete. But in respect of respondent number 1, the Lavazima court directed us to take fresh steps. Thereafter, he came to know that the respondent number 1 has relocated to the state of Bihar. Earlier in the CRP, his address was given in Jorhat. So we have filed an IA for change of address. I number 1891 of the 25.
I number 1891 लिखा सुन. Hard learner counsel Miss
V. Rai.
B. Rai, who has filed this application on behalf of their appellant stroke applicant. For change of address of respondent number 1. As the applicant has learned that the respondent number 1 has relocated to Bihar. Application is allowed. The new address may be submitted by the through a cost title,
You
or
will be allowed to file an amended
Yeah.
cost title.
a new address may be submitted through the amended cost title.
And thereafter, we will be allowed to take fresh steps. upon
Yes,
this,
yes.
right?
And thereafter first step may be taken to respondent number 1. Okay.
Deeply obliged.
In terms of the above observation, this application stands disposed of. Yes, yes.
Item 49.
May I please? Your
Yes,
Lordship?
please.
Also, the IA is for seeking temporary injunction against the respondent lordship. Lordship, the connected regular appeal has already been admitted, Lordship. And the respondent side has also appeared, Lordship, by filing their apology, Lordship. Now, Lordship, since few days ago, they are going to construct a RCC structure over the Suitland, Lordship. That's why I have filed this injunction application, Lordship.
See, IA has been admitted, isn't it?
RSA has been
RSA has been admitted.
admitted.
We'll hear the other side. You issue
Lordship,
notice.
they are going to sense the national character of the Suitland, Lordship. That's why I have filed this application, Lordship. And that is RCC structure, Lordship, not a small structure.
You cannot construct RCC structure immediately. We'll fix the date. We'll fix the
Lordship,
date.
already actually we have
Have notices have been served to the respondents.
a respondent has already appeared. Already appeared, Lordship.
They are not present today.
Not today.
We'll fix a date, we'll hear them.
Lordship,
This will be fixed for orders only. This will be fixed for orders.
Lordship,
only.
my humble submission, an
We did
interim
this 2
injunction,
days, huh?
an interim injunction maybe.
No, we'll fix a date, let us fix a date.
Actually, they intentionally there is.
No,
absent,
so
Lordship,
we'll
today.
fix a date. On that day, if they don't appear, we'll pass an order. Learned Counsel, Mr.
UB Sharma, Lordship.
UB Sharma is present for the appellant. The respondents are not represented today. List this matter on failure of appearance of any of the parties.
Can it be on 17,
Yes,
19
can-
September, Lordship?
19 number 17.
19 September.
This matter will be taken on necessary order may be passed here. On failure.
On the next step, Lordship, my interim prayer may be considered, Lordship.
Okay. On failure or absence of any of the parties, nalage. Learned Counsel for the applicant has prayed for consideration of prayer for interim objection, interim injunction on the next date. So of this matter will be taken up on the next date fixed. List this matter on Kimansle.
Highly objection. Already LCR has been received, Lordship, as per occasion. Highly objection.
But this I is for condonation of 105 days of delay. It is listed for the first time.
Issue notice. Learned Counsel, Mr.
SP Sharma.
SP Sharma is present for the appellant. Issue notice to the respondents returnable within 4 weeks, list accordingly.
Lordship, in this matter, we have been engaged recently, Lordship. We would like to file our objection
all right.
objection in the
Okay. Learned Counsel, Mr.
UB Sharma, Lordship.
UP
UB Sharma, Lordship.
UB Sharma is present for the appellant. 42, no?
42, Lordship.
Is present for the appellant. Learned Counsel, Mr.
She Sharma, Lordship.
C. Sharma has submitted that he has been engaged recently and has prayed for time to file objection
Yes, Lordship.
or counter affidavit.
Objection in the IA, Lordship.
Objection.
This IA is also for injunction. application,
Injunction.
Okay, objection in the IA. List this matter on when
Lordship.
to want.
Kindly on 19th, Lordship.
Lordship, may it come to
Already, Lordship, this case is pending since June 2025.
Last week of DDR. Objection is filed.
Kindly, if
24
19
September.
24. Kindly it be on 19.
It will be difficult for me, very difficult for me. My brain will be saturated.
Okay. Yes, Lordship.
oblige, Lordship.
Wait, in this application, we are praying for correction of the order passed by Lordship. Order passed in MAC appeal number 33 of 2025, dated 5/3/25, Lordship. Lordship, the matter was fixed, appeal was fixed for admission on 5/3/25. And as usual, your Lordship was pleased to admit the appeal. Record was called for and notice was issued. But from after going through the order, I found that there are some mistakes and omissions in the order passed by your Lordship. Lordship, can kindly see the order is annexed at A, 11 part as page 9. You can see her counsel, Mr. M. Talukdar, is present on behalf of the appellant applicant. Whereas there is no application has been filed by us, Lordship. And learned counsel MS L. Sharma is present for the respondent number 3. Only 2 respondents are there, 1 and 2. And further, there is some omission. In fact, Lordship admitted
Definitely, I have
that
not dictated this order.
maybe we have wrongly recorded.
Okay.
Appeal was admitted, record was called for, but that
We'll
is
correct it.
Lordship.
Our learned counsel, Mr.
M. Talukdar.
M. Talukdar for the
Appellant,
applicant, now you are an applicant also.
appellants,
Appellant,
applicant.
appellants, stroke applicants. It is brought to the notice of this court through this application that there were some clerical mistakes and omissions.
Yes.
So stop, it is submitted that in the appeal,
Order passed of
that
On-
in MAC appeal number 33,
Lordship.
stroke 2025,
Lordship.
there are only two respondents arraigned.
Yes.
Respondents arraigned, whereas the order reflects respondent number 3, who stopped. And I have, after considering the submission, comma, the order dated 5/3/2025 is rectified and the word applicant and respondent number 3 is deleted from the order.
Lordship, there are some other mistakes.
Which one?
Appeal was admitted and record was called for. That was not there. Statutory appeal, Lordship. As usual, Lordship admitted it and record was called for.
We'll pass up today, I'll admit it. Now I'll admit it.
Lordship.
Now I'll admit it.
All right.
Now I'll admit it. This order will form a part of the order dated 5/3/2025, full stop. In terms of the above application, above observation, this application stands disposed of, full stop. Ako etia appealot likha. Heard Mr. M. Talukdar, learned counsel for the applicant, full stop. It is submitted that on 5/3/2025, this court has dictated to admit the appeal, but the order does not reflect that the appeal was admitted. Full stop. As it is a statutory appeal, comma, the appeal is admitted. Issue notice to the
Lordship,
respondents.
record may be called for.
Yes, issue notice to the respondents, returnable within 4 weeks. Call for the trial court records, list accordingly.
Lordship, steps by registered courts as well as usual process.
Returnable issue notice to লিখিছিল যে তাৰ মাজত ভৰাই দিয়া issue notice to the respondents as per usual process as well as through registered post with AD, returnable within 4 weeks.